listen to music all day, so you want to listen offline and in the background, and without ads. No worries, that's all in the new music streaming app made by YouTube. Download the YouTube Music app and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
Kia ora tātou, mau mai hoki mai ki tēnei wina. Nā te kai whakawā I mea mai, mā koe tuku he paku whakamuemiti mā mātou, hei para te huarahi kei mua I a mātou. I'll lead us in prayer. Tēnā koutou katoa. Kia ta whai mai koe te ari ki a mātou I tēnei rā, ka tatari nei o ki mātou I a koe. Ko koe hei rinari nā rahi mō mātou I nā wā o te raru. Ko ia mātou ka inoe, ka whakamoemiti, ka whakaproria ki toi no tapu. Amen.
Morena, everyone. Welcome back to day 4 of the hearing for the Ngāti Raukawa and affiliate iwi claims. And we have Mr. Alexander here. I propose we get straight into finishing his cross-examination. Welcome, Mr. Alexander.
Kia ora.
Kia ora. And unless we've got any other administrative matters council wish to raise? No. We're up to Mr. Lewis.
Sorry, Mum, it's Miss Watini.
Yes, Ms. Watini.
Morena.
Morena.
Mum, if I could seek leave to be excused from today, my colleague Amber Evans will be standing in.
Yes, thank you for telling me. Thank you.
Thank you, Mum.
All right. Mr. Lewis.
Tēnā koe, Mum. Tēnā koe, Mr. Alexander. I'll be asking questions just from the main report, so that's documents A217. And today I'm appearing on behalf of Y6501, which is a claim by Tūroa Karatia and Anthony Karatia on behalf of descendants of Ngāti Pakiahu, Ngāti Waiwai, Ngāti Matakore and Ngāti Rangatahi. Also I'm appearing on behalf of Y1913, which is a claim by Kelly Bevan and Martin Wehi Peihana on behalf of Ngāti Tūkorehe. And lastly, another Ngāti Pakiahu claim, which is Y1872 by Hare Arapere and Puruhe Smith. Kia ora.
Kia ora.
So I thought I would just quickly tack on some more consultation questions onto those that were put forward by my friends yesterday. These questions are different, Your Honour. So I want to look at consultation in the case study of the Kuku Dairy Co-op. So just to summarise, again, we have a situation...
Sorry, Mr. Lewis, you've
Yes.
just raised an interesting point, because as I understand the evidence so far, there was no evidence of consultation with anybody in the district before the 1980s at least.
Yes, that was going to be my point at the end.
So you're going to deal with consultation post that period?
Maybe consultation is the wrong word.
Okay, all right.
Yeah. Yes, so in terms of the dairy co-op, so just for your reference, Mr. Alexander, these questions concern pages 281 through to about 289. That's where it talks about the dairy co-op discharging case study. So the situation is we have multiple applications from the Kuku Dairy Co-op to discharge water into the Ōhau River that were granted by the Catchment Board. Would you agree with that?
Granted by the Regional Water Board.
Yes,
Catchment
that's
Board
right.
with its Regional Water Board hat on, yes.
Yes. Those rights were granted despite consistent objections from Māori and Europeans within the community. That's correct.
Yes, there were a major series of objections. Once the hearing started, it turned out that many of the objectors thought that the dairy company was wanting to expand its operations and was wanting to discharge more into the river than it was already discharging.
Thank you.
And when that turned out not to be the case, some of the heat went out of the issue at that time.
So overall, in terms from the perspective of the objectors, I mean, this is another case of where the objectors have very little authority to have applications denied. That would be correct?
Yes, that's the issue, is that the regulatory authority was held by the Regional Water Board, defined by statute, and local Māori at that time, Ngāti Tukorehe, were required to engage as objectors rather than as part of the decision-making process.
So have you come across evidence, either in this district or other districts, where objectors were able to persuade or had the authority or had the bargaining power to persuade decision makers to deny rights? And what does that look like, if so?
Looking at this inquiry district, no, I do not. There's no evidence that objectors were able to sustain objections requiring a denial of the issue of a water right. But often there was a meeting. How can I put it? A meeting of minds, which might have meant that as objectors they did have some influence on the decision that was not made by them, but was made for them by the Regional Water Board acting. So that did happen, but as I repeat, placing tangata whenua in the role of merely being objectors rather than being involved in the decision making put them at that clear disadvantage.
So just to be clear, you haven't seen any evidence or examples of where tangata whenua have had the upper hand in denying such rights?
Oh, I'm sure there are instances, but I can't bring them to mind off the top of my head.
Thank you. Right, I just want to look at the situation of the diversion of the Ōhau River. So that's from about page 208. So I want to look at this in terms of good faith, coming from both the Tū Kōrehe Tribal Committee and then whether it came back to them. So here we have a situation where the Ōhau River floods throughout the year at different times, and this is affecting landowners along that river, that's correct?
Correct, yes.
Is that a natural phenomena, that flooding along the river?
It is a natural phenomenon, but it has been amplified by the clearance of the forests on the Tararua Range, so that the runoff from the hills happens quicker and therefore at a higher peak than it would otherwise have done under natural circumstances pre-1840.
Okay. And if we turn to page 211,
Yes.
we see at the last paragraph on page 211 that around the mid 1960s, a flood protection scheme was initiated by the farmers by way of a petition. That's
Yes.
correct. And then if we jump forward to page 213,
Yes.
again last paragraph, we see in 1972 that the Catchment Board were advised of some design changes that would affect Māori-owned land. That's correct?
Yes.
Yeah. And some of those Māori were of Ngāti Tūkorehe descent. That's correct?
Yes.
That's on the next page. Okay. And so the board, they actually sought consent from the Ngāti Tūkorehe Tribal Committee Board. Was it consent, or did they have discussions and there was an agreement?
The Regional Water Board was required to get the consent of landowners
Yeah.
upon whose land the stop banks would be constructed, or the flood channels would be constructed. So yes, there was a landowner consent required in that instance. Yes.
And so they were aware that the diversion, the cut would be on their land, and that cut would be beneficial to all the landowners upstream.
Yes, the cut was required because of the stop banking and other flood control works upstream. Because of those flood control works upstream, the flow was concentrated, and if there had not been a flood channel across the Ngāti Tūkorehe land, then it would have effectively flooded the Ngāti Tūkorehe land, and the fresh channels might have been, cut by the force of the water at any time. So it was at the flood channel through the Ngāti Tūkorehe land was an integral part of the upstream works, coming down to and affecting Ngāti Tūkorehe, whose land is effectively at the foot of that particular catchment.
So without that cut, none of the rest of the flood protection mechanisms would work. Is that correct?
For Ngāti Tūkorehe, no. But
Okay. Would they still work for the other owners?
yes, they
Along
would.
the
Yes,
river?
yes,
Okay.
yes. But the issue with the flood channel was that the force of the water coming down was in fact so powerful that in having cut that channel,
Yes.
the banks of that channel also got eroded as well.
Yeah.
So that the Ngāti Tūkorehe suffered doubly in that respect, losing some of their land to the flood channel initially, and losing more of their land because that flood channel got widened by natural force of the waters.
Yeah, and that's what I want to look at, because we have a situation where the tribal committee, they seem to be working well with the board to get this flood protection in place that's beneficial for everyone. And then once it's in place, the Tahamata Incorporation, which is further downstream, and they're also Ngāti Tūkorehe, their farmland starts to suffer because of all this work.
Right, okay, well I think perhaps we need to pull back one step. The land I'm referring to as the flood channel through Ngāti Tukarehe land is actually through the lands of the Tahamata Incorporation.
Right, yep.
So that, we're not talking about two different stretches of the river, we're talking
It's
about
the
the
same
same stretch of
Okay.
the river. The issue for Ngāti Tukarehe was that the catchment board pulled back from its willingness initially to extend stop banking and
Right.
other flood control measures further downstream onto Ngāti Tukarehe land, which would have reduced the flooding risk to the Ngāti Tukarehe land. The catchment board decided that that was too difficult because there were difficulties from a tidal water's point of view. It was not just a matter of dealing with the water coming downstream, it was also the relationship between that water coming downstream and the tidal ebb and flow that was also affecting that low-lying Ngāti Tukarehe land.
Okay.
So the catchment board decided that it wouldn't extend the stop banking, it would put the flood channel in,
Yep.
but it wouldn't put stop banking in to assist, to prevent further flooding of the Ngāti Tukarehe land. So that Ngāti Tukarehe were left in the situation, because they were at the foot of that catchment, that they experienced all the difficulties caused by the floodwaters and by the flood control works upstream, and they experienced none of the benefits of the flood control scheme because there were no stop banks being offered to them as part of the scheme.
Yeah, so I mean, it seems like, I mean, at the beginning, they were definitely putting forward a lot of good faith on their behalf, but when they needed it at the end, they didn't receive anything back from.
Yes, well, that's the ultimate. I'm not sure to what degree all of them were issuing good faith to the catchment board. Certainly, the incorporation was offering, through a Pākehā solicitor, was offering good faith by allowing the flood channel to be constructed.
Yes.
But there were other members of Ngāti Tukarehe who were far more questioning of the benefits that they would get from that. And so I'm not sure to what degree Ngāti Tukarehe was in fact speaking as one at that time.
Right. And just on that point, from all that flood protection work, I mean, what were the effect on the marine life along in that river? I mean, the migration of fish up the river. Do we know how they were affected, or is that for another report?
I'm afraid it would have to be for another report because I didn't come across any references in the historical records.
Right.
There may very well be, and in fact I'm sure that there are changes which Ngāti Tukarehe individuals would be very well personally aware of at that area. This is the area, on the Ngāti Tukarehe lands is this inlet in the tidal waters called Blind Creek. And certainly this is an area that was very significant to Ngāti Tukarehe. They took a great deal of interest in that, and yet the works that the catchment board was offering to provide would do absolutely nothing for that area. Now, in doing absolutely nothing, it may be that that left it undisturbed, and that might have been a benefit in terms of the degree, the ability to harvest fish and other foods. But I can't say what the answer was to that.
Okay. Well, thank you for that. Those are my questions. Thank you, Mum.
Thank you, Mr. Lewis. Mr. Tanahu.
Thank you, Ma'am. Tēnā koe, Mr. Alexander.
Kia ora.
My name is Hemi Tanahu. I'm counsel for Ngāti Whakatire Y1640 and counsel for Ngā Hapu o Kereru, including Ngāti Takiku, Ngāti Ngārongo, and their Y1944. Thank you for your report, Mr. Alexander. It's been really great for the claimants that I represent. I'm going to start my questioning around the Manawatu River. Essentially, the evidence you produced in your report is in relation to, in regards to the Manatee River, is in relation to pollution levels, data relating to various types of pollutants, sewage discharges and the like, correct?
Yes.
Would it be acceptable to you, would it not, that the Manatee River is a taonga for the people in this region, a taonga considered as such by the claimants that I represent, and I'm sure for a number of claimants from this inquiry, would you agree?
I can't say. That's for them. That's for the Hapu to say.
Thank you. Would you accept that there's a huge gulf conceptually regarding Māori references of kaitiakitanga, rangatiratanga on the Manatee River as opposed to the concepts of proprietorship principles espoused by the Crown?
Yes, absolutely.
So when we are talking about kaitiakitanga and the rangatiratanga of a taonga under the treaty, you would accept that the Manatee River would be seen as such by Māori, particularly the claimants that I represent?
If that's what they articulate, yes.
We heard from Drs. Helen Potter and Dr. Mahinarangi Baker and others yesterday in regards to their report, and that Manatee River is one of the most polluted rivers in this district inquiry. Based on your own research, would you agree with that?
Yes, I would agree the Manawatu River is polluted, but I believe the Aroa River is more polluted in the sense that the degree of waste discharged into it as compared to its natural flow, it makes it more severe pollution in that river. But that's not to deny the pollution
Yes.
that occurs in the Manawatu River, which of course the Aroa flowing into the Manawatu contributes.
Correct. Repollution of the Manatee River and indeed a large number of waterways in this district. It's your evidence that the Crown, along with its agents, are directly responsible for the massive degradation of water quality in the Manatee River, along with other waterways, with blatant disregard for the protection of the Manatee River, waterways and water bodies in this district, including total disregard for the kaitiakitanga, rangatiratanga and tikanga of Māori over those waterways.
My argument in my paper is not that the Crown is responsible for the pollution, but it is responsible for not ensuring that the pollution gets cleaned up. So that's why I talk about regulatory failure of the pollution control mechanisms established by the Crown.
Thank you. You commence your report by referring to the framework you were contracted by CFRT in order to produce your report, essentially a gap-filling report, correct?
Yes, and the commission was from the tribunal itself rather than from CFRT.
Yes. Consequently, would it be your view that the Manatee River section of your report would be a far cry from what you would say is a fully researched and considered report on the devastation suffered to the Manatee River?
Yes, I think there is much more evidence that is still available and which might be of benefit to the tribunal.
Thank you.
That is not included in my report.
So when you were presenting your Rangitike River report that you mentioned in your report before us at the moment, you may or may not recall when I was cross-examining you there that I asked you whether the Manatee River would warrant the same type of research that you did for the Rangitike report. Is that still your opinion?
Yes, it is. Yes, I believe that there is more information available in the historical record which would assist the tribunal than is provided in my report.
Thank you. I now turn to the Te Awaho Rangitike Manatee blocks that you've, in your report, start discussing in regards to the Crown Purchasing Program.
Yes.
You have determined that the issues of the Te Awaho and the Rangitike Manatee blocks as one of the focus areas of your research was warranted.
Sorry, can you...
You have determined that the issues of the Te Awaho and the Rangitike Manatee blocks as one of the focus areas of your report was warranted.
Absolutely, yes, because it had an impact on waterways.
You discuss at page 44 of your full report how there was confusion, frustration, and I would even say anger felt by Māori of this region due to the complexities of these land transactions. Is that correct?
Yes, and the length of time it took to resolve them.
Thank you. Would you agree that Māori still suffer from anger, frustration and confusion today regarding those Crown actions in relation to those purchasing regimes for those blocks?
I don't have a view on that. They can tell the tribunal themselves about that.
You state that the Crown had issues between sellers and non-sellers in your report. The Crown suffered settlement pressures. Māori were resistant to those transactions, and a raft of negativity began to be exhibited by those Māori. Is that correct?
Yes.
Your evidence essentially states that this type of behaviour from Māori was holding up, should we say, the purchases of these blocks for settlement, and the Crown simply wanted to get the job done. Wouldn't you agree?
Yes. The Crown's attitude, and therefore it comes back to the Crown's understanding, was that it had acquired the Rangitiki Manawatu block in 1869. That was the year that the notice of extinguishment of title was gazetted. Anything after that effectively was resolving an irritant for the Crown that still hadn't been resolved.
So Māori were an irritant.
At that, for their continued objections to that purchase, their belief that the purchase had not been satisfactorily resolved, was an irritant for the Crown at that time.
You do have some concerns, don't you, in your report, that in order for the Crown to get the job done, because Māori were being irritant, resulted in, shall we say, circumspect behaviour on the part of the Crown when it dealt with Māori in this area. Wouldn't you agree?
Again, as I mentioned in my main report, I defer to those historians who have examined that purchase in greater detail than I have. But yes, I believe that the Crown's approach at that time was to resolve the outstanding concerns in a manner that, while resolving them, was had of least consequence for the Crown itself, in terms of the amount of land that was not made available for settlement.
Thank you. Would you have had an opportunity to have read Dr. Anderson's report in this inquiry called The Crown Action and Māori Response, Land and Politics, where Dr. Anderson refers to where Crown were cementing an arrangement that the Crown gave a buried bottle with a coin to reflect that understanding?
No, I'm not aware of that.
Have you found anything like that with the Crown has done that to cement any arrangement with Māori?
No.
Have you found anything in your research where Māori themselves have given the Crown something that, in their view, cements an arrangement or an agreement?
I think I probably have come across that, but I can't bring to mind what it is, and I think it would be a rare occurrence. But certainly there are instances where there is a giftings that which in effect seal the deal, seal the arrangement that is made.
Thank you.
But I'm afraid I can't, off the top of my head, bring to mind those.
Is it your evidence, Mr. Alexander, that no matter what tikanga rangatira would have used in relation to land transactions and the exercising of that tikanga in the rangatiratanga would have been totally ignored by the Crown on the basis, firstly, that the Crown would not have understood the tikanga, and secondly, the Crown simply did not care?
Well, yes, obviously the Crown did not understand tikanga, and that certainly applied in the era of the Native Land Court, so that's 1865 onwards. prior to then, I think that Crown officials, because of the situation they were in, where Māori holding rangatiratanga dominated the landscape in effect, I think Crown officials had a greater awareness of tikanga in the very early purchases, but I think that got lost after the New Zealand Wars, as far as the Crown is concerned.
Thank you. You've made mention in your report that non-sellers were worn down, such as the claimants that I represent, purely to get the job done. Could you explain what you mean by worn down?
Non-sellers expressed their opposition to what the Crown was proposing. The Crown would tend to ignore them, or to go and see other people who were more willing to speak to the Crown, to negotiate with the Crown, and so that the non-sellers could get sidelined, would be unable to represent their interests so successfully as they had hoped they would be able to do.
So essentially the Crown was causing conflict between hapu.
I'm sure that is the case. I'm not prepared to say that was the case for these particular purchases because I haven't examined the purchases to that degree of detail. I'm relying on the historians who have looked at those purchases in more detail.
So when we look at the land purchasing transactions of the Te Awaho block, the Rangiteke Manawatu block, and the other blocks that you researched in your report, non-sellers were worn down. Crown strategies were to cause conflict between hapu. Another strategy for the Crown was to ignore tikanga, where those lands were concerned, was purely for the focus on settlement and Pākehā settlers and Pākehā economy. Would you agree with that?
Yes, that was the Crown's approach, that it wanted to be able to settle as many people as possible on the land. And coming back to the impact on waterways, the waterways were incidental to that, and if they were a casualty, then so be it.
Thank you. If we could turn to now your...
Mr. Tanahu, it's 15 minutes. Do you want to make your major points?
In terms of the ad medium filum eque principle, I have got some questions that I wish to pursue further. Mr. Alexander, I could file those in writing, ma'am.
What was the basic point?
There is discussion on this page 94 where Lakes Waikaremoana and Omapere were lakes where this principle applied. And my understanding of that principle was it only applied to navigable rivers. So is it your evidence that that principle also applied to lakes?
Yes, there is debate in the historical literature, the legal articles, whether at what stage a lake ceases to be a small lake, where the ad medium filum eque rights would apply, in the sense that it's like dividing up a cake around the central point of the lake, as opposed to a larger lake, and it comes back to the lakes such as Rotoiti, Waikaremoana, and so on, where the ad medium filum eque presumption might not apply, but that is left unresolved in the legal literature.
Yes, because I was going to ask...
And we'll look forward to your legal submissions on that.
Thank you, ma'am.
Can I hear now from Ms. Lang?
Thank you, Mum. Tēnā koe, Mr. Alexander. My name is Josie Lang. I represent Y1630, which is a claim by Heitia Raureti for and on behalf of Ngāti Kapu. The majority of my points have been covered by my friends, and in particular, I'm grateful for your written answers to Mr. Watson's questions in relation to the Otaki River, so I won't cover those today. and likewise consultation has been fully addressed, so I won't ask those questions either. So just one line of questioning for you relates to tuna, and this is at page 450 of your report. Sorry, actually starting at page 461. And the purpose of my questioning here is just to explore with you how hapu have tried to engage with Fisheries New Zealand on this issue and the response that they have received. So we have these extensive submissions which were made in 2018 in response to the Sustainability Review public discussion document. And essentially Fisheries New Zealand take the submissions and they recommend to the Minister of Fisheries that the total allowable catch for longfin eels should be reduced, but shortfin eels should stay the same. And this is at page 464 of your report. But what was asked for in the submission process by tangata whenua was a total ban on fishing, and that wasn't deemed to be justified. And one of the reasons given for that refusal to carry out the total fishing ban is that the reliance on the scientific assessment, which suggests that eels were abundant. So my question is, that scientific observation, that conflicts quite starkly with the evidence put forward in those submissions from tangata whenua, and also as you described in your summary yesterday, that there is a savage reduction in tuna abundance. So there's a conflict there, you'd agree, wouldn't you?
Yes, and that's at the fundamental base of the quota management system is an expectation that populations of fish are actually placed under pressure because that would encourage them to breed more effectively, and therefore putting that population under pressure is an allowable matter from a scientific analysis point of view.
Would you also agree that what's happening here is a balancing, a weighting exercise, that the Western science here is being given more weight, more prominence than the evidence of tangata whenua about the state of the eels in their rohi?
Yes, the European science has no regard for tikanga, for the spiritual significance of tuna to Maori, and the harm that Maori feel they suffer as a result of such savage reductions in populations.
Thank you. Now, at page 466, you note that I think there's a discussion paper there of Fisheries New Zealand, and they propose that a mātaetai might be a solution for hapu to exercise, to undertake management of the tuna. And you've noted in your report some of the limitations in the use of mātaetai. It seemed to me that there is a lot of work involved in that application. Do you have any idea of how the cost of putting that application together would be met? Would that have to be something that the hapu provided their own resourcing for?
I'm afraid I don't know. All I do know is that there are no freshwater mātaetai reserves in the whole of the North Island, and quite frankly that surprised me, given that tuna are so important to so many hapu in the North Island.
And I think...
Sorry, I'll give you some extra time. You say North Island, are there some in the South Island?
There are some in the South Island, yes, the Ngaitahu. So the first one in the South Island was on the Mataura River in Southland. There was another one in some coastal lagoons in South Canterbury, and then the most recent ones are 3 mātaetai in the Kaikoura district. So that's the rohe of Ngāti in Kaikoura. And that's why I raised the issue that one hapu of Ngāi Tahu can get 3 mataitai. So what would happen if the 25 hapu of Ngāti Raukawa put in their applications? And I just wonder whether that would break the system or make it or affect the impact of the quota management system.
Thank you. Sorry, Ms. Ling.
And just following up on that, you do note in your report, this is page 468, that you make the point that it's significant that those mātaitai are located in the South Island, and you suggest that it might be a result of that there's a more substantial financial resourcing available for those mātaitai to be requested? Or?
Yes, I just, without knowing the background, I just wonder whether the maturity of the relationship that Ngāi Tahu has with the Crown has a bearing on what they've been able to achieve. Given the fact that they've had a settlement, they therefore have greater financial resources than those hapu who don't have settlements.
And even if the hapu were successful in having a mātaitai established, as you note in your report, this is a multifactorial problem, isn't it? So although they could control the fish, there are still impacts on the tuna fishery that wouldn't be able to be controlled by a mātaitai. I'm thinking in terms of water quality and pollution, etc., that wouldn't control those factors.
That's correct. The mataitai are established under fisheries law, which is solely concerned with fisheries and not with the fishery environment.
Mm. Just finally, in relation to closed catchments, is it your evidence, I think you mentioned this yesterday, that you haven't found any examples of closed catchments in this district?
Not in this inquiry district, no.
You also made a statement yesterday when you presented your summary that it seemed to you that the Crown wasn't promoting them, and I just wondered if you could explain a bit more about what you meant by that statement.
Yes, when I saw that Fisheries was advising their minister that there were options available, I thought, oh, well, let's look on the Fisheries website and see how you can apply. And I couldn't find any opportunity to apply. And then I looked and said, well, how is it that you can get closed catchments? And it seemed to me that the closed catchments were, I won't say a historical relic, but they were a result of historical circumstances. And it seemed to me that the option of having closed catchments might have been and gone, might not be available in the present day, because a lot of them, the particular one that I know is about the Mohaka River, and that was specifically as a result of a settlement there. And it may be that that is tied, the closed catchments of the Whanganui River, parts of the Whanganui River, another closed catchment, that could be the reason that they are historical in the reasons they were set up, and they're not so available today. But I don't know the answer to that.
Thank you, Mr. Alexander. Those are very helpful answers. Thank you.
Ms. Brown. Sorry, I've got Mr. Lahat first. No? Yes. Yes? Thank you.
Tēnā koe, Mr. Alexander. My name is Chris Lahat. I'm appearing for Y2197, which is particularly concerned with Ngāti Pariwahawaha and the surrounding lands in the Rangatike River. One of the issues that they have is that the
Sorry,
flooding...
Mr. Lahat, when you say concerned, are there a claimant of that hapu, or
Yes.
are they representative of that hapu?
Well, this is an interesting issue because...
Well, it's an easy one to answer.
my client Oma Heitia insisted that she was the correct claimant for this hapu. There are other people, in particular Mr. Savage, who are appearing saying they're representing the hapu, but I have extremely clear instructions both from her before she passed away and from her family that they are the people who can whakapapa to the ancestor Hare Rewati, and that they are the appropriate claimants for this part of the claim before the tribunal.
Yeah, there's no doubt she has the right to be a claimant. I'm not suggesting otherwise. I just need to get clear, as we did during the kōrero tuku iho process from council, who are the representatives of the hapu, so that we know that in terms of how we deal with issues that emerge during hearing. So you're saying she claims to be the representative and there are others who claim to be representatives, and that's enough. That's all I need to know.
Yes, the claim.
Thank you.
Yes, the claim is now with Jason Cribb. I want to talk about the flooding of the river and the effect on the surrounding land. There are a number of consequences, one of which you refer to in your report about how the movement of the river meant loss of land, in particular to the hapu and to surrounding areas at Ohini Puiawe. Would it be an appropriate proposition that this hapu has suffered substantially from land being taken by the Crown applying this principle of ad medium filum aquae, so that the Crown tended to take the bits of land which they thought they needed and rather left it up to the hapu to have what was left?
Right, well, there's a number of different issues there. The first one is we're dealing with Ngāti Pariwahawa,
Yes.
whose rohe extends down to Foxton. Their area of interest extends down the coast as far as Foxton and up the Rangitikei River, to including Ohine Puhiahi. In that wider sense, I don't think the ad medium filum presumption applies in a harsh manner. But when you look solely at Ohine Puhiawe, then you have a different situation, which has been discussed in my Rangitikei River report, whereby the river changed its course naturally, and that particular reserve got severely affected by the change of course, so that they lost a lot of productive land to the river. Some of that land in the old bed of the river was returned to them, relying on the ad medium filum aquae presumption. Eventually, although there was a large legal argument that took place before that could be resolved, and then they lost a lot of their land under the Public Works Act to the Catchment Board, because the Catchment Board felt that this land originally granted to Ngāti Pariwahawaha as a Maori reserve was now part of the new riverbed of the Rangitikei River, was better to be held in the Catchment Board's hands, because that would enable the Catchment Board to operate its flood control scheme with fewer impediments than if it was in private ownership.
Thank you. And did that also enable the Catchment Board and others to extract metal from the river as they sought fit, rather than consulting with the hapu?
That was one of the motivations for the catchment board wanting to get the new bed of the river into its hands, was that it could then have a free hand in dealing with gravel extraction.
And was there, in fact, quite a lot of extraction of metal prior to the catchment board taking over, so that was effectively people just helping themselves? I expect it was Pākehā settlers around and others.
Yeah, I was not able to resolve that. There definitely was gravel extraction from the old bed of the river while it was still in Maori hands. I do not know to what degree that was with the permission of the Maori landowners. I do not know to what degree that was with the permission of the catchment board. Almost certainly it was with the permission of the catchment board, and the catchment board itself took some gravel from there. But there was an argument at the time as to the quantities involved. The catchment board argued that the quantities were quite small, and the Maori owners, Omar Heitia in particular, who was vigorously central to the claims for compensation for loss of gravel, that they argued that more gravel had been extracted than the catchment board was claiming to have extracted.
And are you aware that there's still a strong feeling within the hapu that the compensation has been inadequate and simply doesn't recognise the profits that were made by others?
That's why I say there's an argument as to how much has been taken in the past. Effectively what happened was Mrs. Heitia took the catchment board to the Land Valuation Tribunal when in arguing how much compensation should be owed to the Maori owners for the loss of their land for its taking under the Public Works Act. And the catchment board initially argued that it didn't need to pay for gravel. The Land Valuation Tribunal effectively decided that it should pay a premium for the gravel that was included in the riverbed. But as sometimes tends to happen with these tribunals, the amount of compensation was about halfway between what the catchment board was offering and what the Maori owners claimed.
What sort of effect does large-scale extraction of the gravel have on the river itself? And it's a wide-reaching question because I'm referring to things like abundance of tuna and other food sources from around the river and the state of the river itself.
Right, yes, it's a wide question. The first issue with gravel is that from a catchment board point of view, from a flood control point of view, they do not want to see banks of gravel in the waterway because that reduces the capacity of the waterway to have that extra gravel. If your gravel is depositing in a particular part of the riverbed and is raising the bed of the floodway, then the capacity of the floodway is affected. So that from a flood control point of view, there are arguments of wanting to remove gravel when it is an impediment to the flow of water in the floodway. The flip side of that is that if too much gravel is taken from a particular spot, then you start to get erosion taking place. If you dig a hole in the bed of a floodway, you will start to get slumping on either side, so that effectively starts to affect the banks of the floodway. So from a flood control point of view, they're trying to find some balance in between those two spots of deposition and artificial removal, which is effectively a form of erosion. In terms of the impact on the natural environment of the waterway, the issue, in fact, is that you've had a wider a wider effect on the natural waterway already with the other flood control measures that have taken place, the actual creation of the channel itself, the building of stop banks on either side, so that the environment of that waterway has already been severely impacted, has already been affected away from its natural state already, so that the effect on fisheries life in particular is it's deleterious for fish life, in the sense that the stop banks and the artificial banking, the artificial channeling is less conducive for matters like inanga, for whitebait, for spawning on the banks. It's less conducive for having backwaters which tuna can go into. As far as the rangitika is concerned, it's less conducive for patiki to travel upstream. They require in effect sandy beds rather than gravel beds. So all of these matters affect the natural environment and therefore affect the fishery in more ways than just gravel extraction itself.
Are you able to comment as to whether there was excessive extraction of gravel which would cause those problems?
There has been excessive gravel extraction on both the Rangitikei and the Otaki rivers, because from a catchment perspective, the engineers are keen that the system is in balance, that the amount of gravel that is contributed from higher up the catchment is not exceeded by the amount of gravel that's extracted, so that that has been the case in the Rangitikei and the Otaki rivers, that there has been more extracted than there has been replenishment from a further upstream.
Are you aware of any consultation with any of the hapu and iwi about the construction of the stop banks and other flood control measures?
I'll come to the Rangitikei first. No, in my report, it's the flood control schemes that were established on the Rangitikei, and there have been 4 different schemes. There was no consultation, and the last review that was held on the Rangitikei of the schemes on the Rangitikei River, the review had a provision for the consequences of the scheme for Maori, and that on the review that I looked at, that page was blank.
And that brings us to the end of your 15 minutes. Thank you.
Thank you.
Did you want to make any vital point, Mr. Lahat, with this witness? We've already established the issue around consultation.
I just wanted to add a supplementary question to whether there was consultation about the commercial extraction of the gravel.
Quickly put that then.
No, the gravel extraction has occurred over many, many years in the Rangitikei, and there was no consultation. The first opportunity for consultation was in the early 2000s.
Thank you.
Thank you. Ms. Brown.
Tēnā koe, Your Honour, and tēnā koe, Mr. Alexander. Firstly, I just wanted to say a big kia ora for your report, dealing with really complicated subject matter, so thank you for your research. I'm just going to ask some general questions today. I'm here on behalf of our client, John Rewiti, who is part of Ngāti Waewae and Ngāti Pariwahawaha. They are situated along the Rangitikei River, and I understand that you've done a comprehensive report on the Rangitikei River. So this is just more general ideas. And I want to build on the kōrero you gave yesterday about the expectations of Māori around their waterways and the different the different expectations and ideas that Pākehā and tangata whenua had, especially around that period of the early Crown purchases. So I'll just be asking questions from your main report and also your summary report as well, which I believe is A217C. So an issue woven through your report, but particularly in the section on Māori understandings of early Crown purchases from page 17 onwards, and mentioned specifically in your summary at paragraph 11, is that Māori continued to retain a significant interest in waterways, but it didn't manifest as an assertion of ownership and control. And I just wanted to clarify that around the time of these early Crown purchases, Māori were still living around in the area and vicinity of rivers and waterways, weren't they?
Yes, that's correct.
I guess my question next is, was there a need for Māori to assert the ownership, i.e. was there sort of settler use and abuse which necessitated the need for Māori to assert their control and ownership over their waterways?
I believe it would have been very quickly apparent after the settlers were originally placed on the land that there were changes that would affect their waterways and therefore affected the what I call the fishery ecosystem. So that's the degree of wetlands upstream of tuna fishing sites. That would have been apparent to the people fairly early on in the piece. They were. Having said that, the effect of drainage of wetlands and so on was not something that happened overnight. It was something that happened more slowly, certainly slower than the change of land titles, and so that there was a cumulative impact of the progressive drainage of wetlands, which would have had a progressive impact on the fishery.
Yes, and I guess, you said that there was a reduction in assertion. Do you think it's because Māori believed they still had ownership and control of their waterways at this time?
I can't say, because I can't see anything in the Crown records that I examined that would suggest that.
Okay.
That doesn't mean to say that the Maori might not have held that belief.
Yeah, and I guess, from what I gathered in your report, the Crown wasn't forcibly depriving Māori of their rights in terms of ownership in waterways. It was legislating slowly for the taking away of rights. It was sort of more, I'd say, insidious as opposed to overt. Would you agree with that statement?
I agree that the impact of the Crown's statutory legislation spread the Crown's cloak more effectively over the water space over time, yes. Yeah, I guess I'd put to you that the likely situation is that Māori maybe didn't fully comprehend the impact of the implemented legislation. And I don't mean comprehend as in not to say that they didn't comprehend it, but they, maybe the full effect of it wasn't apparent straight away. I don't feel I can comment on that.
Okay, sure. On page 99 of your main report, you talk about the Himatangi Crown Grants Act, 1877. This returned the waterway rights to Māori after the Crown had acquired them ad medium filum. Is it possible that this was because the Crown recognised that despite the Crown's acquisition, that Māori actually continued to exercise mana and rangatiratanga over the waterway?
This is the Maori Land Court in 1941. Its interpretation of the effect of those titles was that having granted a title to Maori out of the lands that the Crown had acquired, then a presumption made by the court was that the grant included the ad medium film presumptive rights to the waterway in the same way that the Crown had acquired those presumptive rights through the Rangitiki Manawatu purchase. That was the court's opinion at that time.
Yeah, so they've returned, the interpretation is that the rights have been returned, but within the Pakeha common law system.
Yes, yes, and the
rights.
interpretation is also that that purchase in 1869 included the presumptive rights in that purchase, yes.
Sure. And just my last question here for you, Mr. Alexander. On page 24 of your summary, you say, customary rights and authority held by hapu have mysteriously disappeared from view without clear evidence of them having been explicitly extinguished.
Yes.
So are you saying, Mr. Alexander, that on paper, customary rights and authorities seem to have been taken by the Crown, but in reality, it's never accepted that they were taken at all?
I'm saying that the argument is put forward that there were Aboriginal rights existing pre-1840, that those Aboriginal rights survived the circumstances of 1840, in particular Te Tiriti, and in particular the proclamation of sovereignty, that those rights then got lost to view in terms of being Aboriginal rights, then got lost to view through what I think of as the collective amnesia of the legal profession for over 100 years.
And I guess that a matter of Aboriginal rights is for legal submission. So thank you so much, Mr. Alexander. And once again, thank you for your extensive research. And those are all my questions, Your Honour.
Thank you. All right, Mr. Stevens.
Mr. Morrison is actually going to
Thank you,
speak
Mr.
to
Morrison.
Alexander.
Tēnā koe, Mr. Alexander. My name is Tim Morrison. My questions are on behalf of the Crown. So the first topic I wanted to look at is kind of a theme that you explore around a lack of consultation with the Māori owners of leased land. So at page 69 of your report in chapter 3, where you're looking at the mechanisms for loss of ownership and control of waterways. At the bottom of the page, you talk about sort of the standard clauses in leases, which included clauses that insisted on good husbandry of land and set expectations that the leased land will be transformed into farmland and maintained in that condition. So from your summary yesterday, you explained that, in your view, at the time of the early Crown purchases, Māori had an understanding of what acquisition of land by settlers would involve in terms of the development of that land. I'm just wondering, would that background also have been understood when entering into leases over land?
Possibly, yes. The issue I'm trying to raise here in discussing the terminology used in lease documents is that they were very much, the standard that was set for them was very much written in terms of agricultural development, and was not written in terms of maintaining the natural environment of waterways.
And so there was an economic trade-off there where, in order to have the return from leasing land, it came with the trade-off that that land would be developed into farmland.
Yes, there was a trade-off, but I think it's also a reflection of the wider opinion that lease documents were very much standardised in terms of the clauses that are included in them. I think if there was an analysis ever made of historical lease documents, it would be found that they were relying on a particular template that had been set, and that template was very much agricultural development oriented in terms of setting the obligations on the lessee, who is a farming lessee, as opposed to the rights remaining with the lessees. No, with the lessors, sorry.
And just interested in how that flows into the consultation or lack thereof that you identify later in your report. So at page 209, you note
Yes.
in the bottom paragraph of that page that a feature of catchment board records is that the board was primarily concerned with the occupier of the land, and less so with whoever might be the owner. And at the bottom of the paragraph, that consultation with Maori owners of leased land was not a standard part of the, for example, the Manawatu catchment board's operating procedures. So that lack of consultation reflected a commonly held understanding in terms of leases that the lessees had a right to transform the land, and perhaps consultation was not needed because of that established expectation.
I think that's a fair comment, yes.
And also, just wondering whether you came across in your research whether your observations about lack of consultation with the owners of Maori land extended to land that was non-Maori owned. So if there was a lessee of European owned land, were they consulted? Was that apparent in the records at all?
The consultation, as far as I was concerned, was with whoever was paying the rates. And that tended to be the lessee, because that tended to be one of the clauses in the lease, was that the lessee would be responsible for paying the rates. So from the catchment board's point of view, it was the rate payer was the piper who was paying the tune.
So there may not have been, I guess, a difference in treatment based on who the land was owned by. It was just the fact that the land was leased and the lessee was the rate payer.
That, in my opinion, was the state of affairs. It was acknowledging the legal landscape in terms of who had responsibilities for what.
If I could just move on to Chapter 4, which looks at the application of common law and statute law to the beds of inland waterways. And just looking at your concluding remarks at page 152.
Yes.
So you note that in relation to the Coal Mines Amendment Act 1903, Crown lawyers acknowledged that there was uncertainty about its application, but Crown officials were prepared to assert the concept of navigability and therefore a claim to ownership over beds of navigable rivers. And then over the page on page 153, you note that the gains for the Crown, at the bottom of the first paragraph, the gains for the Crown from taking the approach that it did were strictly limited and do not deserve to be overemphasised. I just wondered if you could expand on why you say the gains were strictly limited.
The gains were limited in the sense that the Crown never sought from the courts, and the courts never gave a clear answer in favour of navigability, so that it continued to be an assertion by the Crown rather than a settled matter of law.
So did the Crown obtain any practical benefit from those assertions at the time, despite the fact it wasn't determined by the court?
Well, I think so, yes. I think that the Crown was in effect placing itself in the box seat and was giving itself greater authority because of the assertion that it advanced and continually advanced and continued to support through its approach. Bearing in mind that government departments have a great deal of credence in the community, and if they advance an assertion, then that is not so readily able to be challenged as if it was put forward by a private individual.
If I could move on to Chapter 5, which looks at the impact of waterways management regimes, and particularly just some questions around the local bodies that were involved in carrying out flood management and drainage work. So you introduce at page 157 county council drainage districts. So in terms of the decision making as to the drainage works in those drainage districts, would those be made by the county council?
Yes, they would be usually made by the county council, but sometimes the county council will establish a subcommittee to manage a particular drainage district. But effectively, you know, from how can I put it, from a legal perspective, it was the county council itself that had the power given to it under the Counties Act. It was the county council itself that collected the rates relevant to it, and then it operated within that particular drainage district in accordance with what a county council resolution told it to do.
And in terms of the priorities for the drainage work for that county council, that would reflect the priorities, I guess, of the ratepayers within that council.
The ratepayers within that district, because the effect of establishing a drainage district was that a county council could charge a special rate to those particular ratepayers in that district for works done in that district.
And on page 162, then you discuss the establishment of drainage boards under the Land Drainage Act 1893. And you refer to those as autonomous local government organisations established by order in council. So I guess similar to drainage districts, the decisions around the drainage work to be carried out are made by the drainage board itself?
Yes, that's correct.
And
the drainage boards had to operate within the confines of the Land Drainage Act, but within those confines they could decide what would happen within their district.
And you suggest the position is somewhat different moving on to the establishment of catchment boards. So it's at page 197. Just in the paragraph below the quotation, you say that regional catchment boards are thought of as a halfway house between direct government, central government action and action by local authorities such as county councils and river and drainage boards. And just interested in exploring the extent to which the central government controlled the activities of those catchment boards. So I understand that you explained yesterday that the central government was able to appoint 5 of the 15 members on a particular catchment board, and also that catchment boards are subject to an oversight role and approval for funding through the Soil Conservation and River Control Council. was there kind of a national level policy in terms of areas of priority for drainage and funding that was, I guess, administered by the National Council?
I don't know. I don't have an answer for that. I suspect that those people on the National Council would have had some general views about priorities, but I don't know whether they ever established them. They were not established in legislation. The issues in legislation were primarily the degree to which any Crown funding would contribute to economic growth, and in particular to farm production, increased farm production. So, and that was turned into financial figures as the measure for that increased growth. But that was the motivation behind the Crown's involvement in providing subsidy funding, was to see economic improvement in the various agricultural districts that were affected by the catchment schemes.
So I guess, was there any top-down decision-making where the National Council was able to, I guess, direct a catchment board that it needed to carry out particular works within its region, or was it always the case that a particular proposal for a drainage scheme would be formulated by the catchment board and then brought up for approval by the council?
Yes, on the face of it, it was the responsibility of the catchment board to initiate the process and to produce a draft scheme and to forward it to Wellington for approval at the national level. In practice, I think you'll find that it was a two-way process. The engineers were talking to engineers in both directions, so that they were, at the national level, they were seeing that there were certain things that should be done and that needed to be done. The other thing, of course, is that the catchment board engineers at in the districts had to be very aware of what the Ministry of Works engineers in Wellington would think about things. They would only put up proposals which were likely to get accepted, so that the Crown held all the cards in the sense that it could decide not to support a particular proposal that was put up to it by a catchment board. And it could decide that either on the grounds of the engineering-wise the proposal was unsatisfactory, or it could decide not to support a proposal if the economics didn't stack up as far as the Crown saw things. And it was not just the Ministry of Works that that ran its eye over the economic numbers. It was Treasury as well that did so.
And in your review of catchment board records, did you get an idea of the total amount of sort of Crown subsidies provided for the inquiry district as opposed to other districts of New Zealand?
No, I never looked at it in those terms, so I can't answer that.
So just moving on to look at some of the significant river control and flood protection activities. On page 184, apologies, you talk about the effects of the Whirakino and Taupunga cuts. So at the bottom of page 184 and going over to page 185, you say that the Whirakino cut, like the Taupunga cut, was another part of the scheme that would affect the low proportion of Māori land in the scheme area, and it would therefore directly impact on Māori. So just interested in the fact that you say, despite there's being a low proportion of Māori land in the scheme area, that land was affected by these cuts, I guess, was there any conscious consideration of who the owner of the affected land was, and was there any, I guess, decision to go through Maori-owned land in particular when preparing the route for a cut?
No, I did not discover that. As far as I was concerned, it was solely done on engineering considerations as to where a cut was required, and there was the ownership of the land was irrelevant, and the issue there is, of course, the ownership is irrelevant when you've got the force of a Public Works Act behind you, which allows you to take land regardless of who's the owner.
So the fact that that low proportion of Maori-owned land in the region, in the scheme area, was affected was simply because it was determined that that was probably the most cost-effective and efficient route for the cut to go down.
Correct, yes.
And just continuing in that paragraph on top of page 185 in relation to the Whirakino cut, you note that the new work would cut off land access to 3 Maori blocks, and that henceforth access could only be by boat across the Foxton Loop part of the Manawatu River. Just turning back over to page 182, the quote at the top of the page, I understand, is from a report from Grant, the engineer working on the scheme. And he notes that of this northern portion being sections of the Matakarapa block, which is the only developed area and is a native occupation, the present access is by water across the river at Foxton, and no alternative access will be required. So I guess just wondering whether the cut had any effect on the access if it was already by water previously?
I think the grant is referring to legal access. Basically, Matakarapa was on the southern side of the Manawatu River prior to the cut being formed. Foxton was on the northern side of the river. So yes, it was a simple matter to have access by boat from Foxton across the river to that Matakarapa land. But because it was on the southern side of the river, there's no saying that the river was always accommodating of that access by boat being allowed. If there were floods and so on, that could have affected it. And I'm sure that there was access by land on the southern side of the river as well.
So just moving on to look at the Otaki drainage scheme at page 236. The paragraph at the bottom of the page notes that the Catchment Board applied for permission to include further work, which included extension of the scheme area to include the Wairongamai stream. And then in the quotation below that, going over onto page 237, it notes that the owners of the property are very keen for this work to be done and prepared to be rated in a higher class if it's done and maintained. And the following paragraph following that quotation, you say that there's no mention that the owners of Lake Wairongamai and its surrounding titles were Māori. So I understand what you're saying in that paragraph is that you weren't able to confirm whether those owners are the owners referred to in that quotation.
Yeah, the issue the difficulty I have is knowing whether it was the owners themselves who were directly dealing with the Catchment Board, or whether it was an intermediary. And bearing in mind that this the lands around Lake Wairongamai were part of the Manawatu Development Scheme, which was a Native Department, Maori Affairs Department scheme. It's very possible that it was Maori Affairs Department officials who were dealing with the catchment board rather than the actual Maori owners of the Wairongamai blocks. Again, this comes back to an issue that I've alluded to, that both the Maori Affairs Department and the Maori Land Court, their actions assisted land development, and whether they balanced up the impact on the lakes and the waterways in deciding to promote land development is an issue which I was not able to resolve, and I rather suspect that they were motivated by land development at the expense of the natural environment.
Would you add the Māori trustee to that?
Oh yes, I would, yes.
So just at the bottom of that paragraph, we note that, in your opinion, it's possible that the catchment board was in discussion with the Native Department rather than directly with individual owners. That would be the Native Department in its own interest rather than sort of as a representative of those owners.
It was the Native Department taking a particular aspect of the Maori owner's interest into account, and whether that was whether land development as that particular aspect it took into account reflected the views of the owners fully, or whether they might have had second thoughts if they had been aware of the impact of what was being suggested might be on the lake, I can't say.
And just turning over the page to page 238. In the second paragraph after the quotation, the second half of that paragraph, you note that it's also apparent that some Maori at least shared the Native Department's enthusiasm for land development and the use of waterways in furtherance of land development. As the fewer restrictions there were on land development, the higher could be the return from farming and from lease rentals. So it might be hard for you to answer this on the spot, but how many examples, I guess, did you come across of Maori landowners expressing enthusiasm or support for, I guess, land development or drainage works?
Okay, it comes back to which time period we're talking about. When it came to land development schemes initiated by Aparana Ngata in about 1930, there was widespread enthusiasm for what he was suggesting because Maori had never received any support of that nature from the Crown in the past. And this was a new opportunity that would benefit them. Having established a role as an assister of land development, the Crown then didn't drop that role when Aparana Ngata ceased to be involved. It continued that role. In the 1960s, it supported amalgamation of titles and the like to strengthen the ownership issues to the benefit of land development that took place at that time. So that once you had got the momentum developed from 1930, that momentum continued, and the momentum continued for Maori being supportive as well. But what I'm trying to say is that it was whether that view was shared by all Maori, I can't say from the Crown records that I examined.
So if I could then just move on to some questions about pollution management. So starting from page 268, where you look at the case studies for permits issued by the Pollution Advisory Council, and in particular at the bottom of the page, looking at the Fielding sewage treatment plant discharge. So you just note in the paragraph under that heading that the need for further treatment of Fielding sewage to replace the communal septic tank that had been in operation since the early 1900s and which was best practice treatment when installed came to a head in the 1950s. And over the page, the Borough Council sought professional engineering advice about how best to treat its sewage. And you explain the best practice of the day, which each of the treatment options still at that time required discharge of wastewater into waterways. That's correct?
Yes.
And when you refer to, I guess, best practice in that context, that would have been based on the, I guess, professional advice to the decision makers at that time.
Yes, water at that time, 1950s, 1960s, waterways were the primary means of disposing of waste in New Zealand.
And I guess from your discussion yesterday, best practice in that sense was there was an opinion that the safest way to remove wastewater was through waterways.
Yes. That had been well established over many years and was still ongoing at that time.
So we've heard quite a bit of discussion about, and it's noted later in your report about the strong views of tangata whenua about discharge of particularly human waste into waterways, and that any level of discharge is offensive. So I guess given your observations about that best practice, was it an option for the borough councils in, I guess, the early to mid 20th century to discharge wastewater without it going into waterways?
Yes, it was an option, but it would have been a more expensive option at the time. So that the reason it was putting it into waterways was a cheaper option was firstly because all the sewer pipes flowed by gravity to the lowest point in a catchment, and that was beside a waterway. So that that was where treatment plants tended to get established. So there was a built-in investment, pre-existing investment in that sewage system for that. But also, as we say, it was accepted practice at the time that the waterway could be used to dispose and dilute of wastes. As that was the case, then and the pipe work was heading towards the river anyway, there was a natural inclination to use the river.
So if I could just move forward to the case studies under the RMA, also in relation to the sewage treatment. There's been quite a bit of discussion already about the process for the Fielding sewage treatment plant and the various delays involved in that and the opposition to continued discharge to water. Just at page 363, in that second paragraph on that page, you note that submitters could be forgiven for suffering from submission fatigue or disillusionment, but that was not a problem for the regional council or district council and their staff, and that they could have no empathy for or experience of the difficulties that voluntary work to protect the environment created. So I guess, could you just expand on what you mean by having no empathy in that context?
Yes, I can. Yes, the staff of the local authorities were going to get paid anyway, whether they worked on this particular project or on some other project. The consultants were going to get paid. The iwi were operating in their own time, voluntarily, putting their energies in their spare time into protecting the environment. It was not an even playing field for the parties involved. So that I believe that the regional council staff could not appreciate the additional burden that was faced by hapu representatives in promoting protection of the environment.
And so another one of the case studies that you looked at is the Foxton sewage treatment plant. That's from pages 385 to 409 of your report. And I guess the experience there is consistent with the experiences in terms of Fielding and Shannon, where there was sort of continued opposition to discharge of water to waterways, but extensions of the existing consents due to delays in, I guess, the processes between the regional and district councils. So in terms of the end result of that the process, as set out at pages 408 and 409, so on page 408, you note that in going through the Environment Court process, the Māori cultural issues were able to be resolved by agreement. And at the bottom of the page, that the consent that was issued finally was one that would allow discharge to water for a set period until land irrigation was set up, and then from then on, discharge would be to land only. So I guess just interested in your perspective on how successful an outcome that is for the iwi and hapu involved, the fact that I guess their submissions have had some effect in the fact that presumably it will be only discharged to land from 2022, but it's taken the time to get to that point.
Yes, that's my concern, is what I think of as excessive delays in the preceding years before getting to that point. We are potentially at that point with all three of these sewage treatment plants that I use, where we can see a final result of one sort or another. But we still have to know whether those standards that have been set, have been included in the various consents, can actually be met in practice. So we're still waiting, as I say, we're still waiting for that to be resolved. So there has been progress. It has been far slower than it should have been. It has put the hapu involved in each of these three cases to an inordinate amount of effort to get to that stage, even when the primacy of not discharging human waste into waterways is set out in the one plan, in the region, in effectively the regional policy statement section of the one plan. It's saying that that's what we should be aiming for, is no discharge of human waste. That's been in that regional policy statement since the 1990s. Even before then, everyone was conscious that all of these sewage treatment plants were underperforming. They were not meeting the standards even of the day, let alone what is now the standard set today. So we've got a lot of I won't call it bad blood, but there's a lot of ill feeling has been involved, has been created in getting to the place we're at the moment. And I think that was unnecessary to put the hapu through that experience for so long. That's the points I'm making.
And I think in your concluding remarks, you describe it as a sort of multi-generational regulatory failure by the Crown. I guess more recently, in terms of the RMA context, do you see it as a problem with the legislation or the actual application of that legislation by the regional and district councils? Because I think you discussed yesterday the problem about the close relationship between those councils and the difficulty in terms of enforcement.
I have problems with the RMA in its general sense. I have problems with the fact that a consent can be issued for 35 years, which I see as effectively bringing a standard up to effectively a plateau, and then let it stick there. And it may be that best practice moves on, but you've got that plateau established. And if you then got the inertia established not to move beyond that up to the latest best practice. So I do have issues with the whole RMA philosophy in that sense. Having said that, we've had issues with pollution going back to the beginning of the 20th century and probably back into the 19th century when it comes to sawdust and so on, wood waste going into the rivers and flax waste going into rivers. So we've cleaned up some of it, but we've not cleaned up all of it. I refers to an analysis by a historian on environmental history of the Manawatu, who's identified 3 eras of waste. The first waste was where what we called gross wastes going into rivers, where there was actually no filtering at all of what was being put into the waterways. That has got cleaned up. Yeah. The second stage is what's called point source discharges, where you get discharges of waste at a particular source going in, and so that has not been cleaned up yet. You've still got it at Fielding, where there is discharge into the river. You've still got it at Foxton, where there is discharge into the river until 2022. But the third era that is being talked about is what's called the non-point source, which is the discharges off the land. So that's the results of agricultural fertilisers and pesticides and the like, getting into waterways in a diffuse manner rather than at particular points of pipes going into the river. So you have got the point source discharges have still not been resolved, even as these non-point discharges are assuming greater impact on the receiving waters. So the waterways are still suffering from pollution, and that's why I'm arguing that the regulatory mechanisms have failed, not just now, but they have failed in all preceding generations up until today. And as far as I'm concerned, the jury is still out on how successful these latest consents can actually be, bearing in mind, as I have drawn attention to, the one review report that I saw from the Manawatu-Wanganui District Regional Council, which looked at all the various sewage schemes throughout its region and found so many of them were not performing adequately. They were not compliant with the conditions of their consent. And the council was, in effect, just saying, well, that's the way it is. Rather than being activist in trying to resolve that in a public sense, it was actually hiding that information from the public and was not drawing attention to it. Perhaps hiding it is the wrong term. Not drawing attention to the lack of compliance with the consent conditions.
Sure. And just on that point, since the writing of your report, are you aware of any subsequent reporting in terms of the compliance with those consents?
No, I have not looked at that.
I think my time is almost running out, so just one final question in relation to Mataitaia reserves, which you've already discussed to some extent today. So just wanted to confirm, the process for establishing one of those requires an application. And are you aware of any application having been made at all?
In this inquiry district, no, I'm not.
So it's more an issue of the process towards progressing the application rather than an application being rejected, for example?
Yes, and it's the encouragement by the Ministry of Fisheries for receipt of applications as well. There's no, I don't think it's got a very receptive environment if I look at on the website.
Just one final question. Going back to page 163, under the heading Crown Managed River Control and Flood Protection, you note that floods and freshers made life perilous for settlers along the banks of rivers. Their homes could be threatened and their lands could be eroded away. Just wondering to what extent that observation also applied to Maori living in the region, or were they better adapted to those kind of floods and freshers?
It's not that Maori were better adapted, it's that the environment was better adapted. Because the forests on the hillsides had not been cleared, then the flooding was not so severe. There was flooding, but it was not so severe, it was not so frequent. Therefore, the hapu who lived along on the banks of the river could live with that degree of flooding far more than they could with the increased rate of flooding and the increased size of floods that have happened once the upper parts of catchments have been cleared of their forest cover.
Are you aware of any flood protection or drainage works that were carried out by Maori, I guess, before or at the time of earlier settlement?
Not flood protection, but the word works carried out by Maori using the technology they had available to them, and that's seen with the tuna drains at Lake Tangimate. That they were prepared to do earthworks if that was of benefit to their lifestyle. Yes.
Thank you very much for your answers and also for a very detailed and useful report. Those are all my questions, Your Honour.
Thank you, Mr. Morrison. I just, before the panel begin asking questions, there was one question or a couple of questions put to you about page 268 and the issue of what, in your view, is best practice at the relevant times. Those case studies relate to, and I think your answer in the end, or your evidence, was that you thought it was accepted practice rather than best practice. Is that right?
Yes, yes, it was what was accepted as best practice at the time.
What was accepted as best
Yes.
practice? Do you want to tell us whether there was an alternative practice that could have enhanced the rivers rather than cause their pollution?
Well, obviously, if these sewerage schemes, the pipe work, was all going to a communal septic tank, for instance, initially, and that septic tank was deliberately constructed on the riverbank because the government, and I have referred to that when discussing the 1912 legal case or the proposed legislation in 1912, the government's view at the time was that these septic tanks effectively are there to catch as much, to catch the gross pollution and so they're like a filter. You pass it through the filter beds, and what comes out at the bottom of the tank is allowed to go into the river. Every now and again, you get a huge amount of sludge accumulating in these septic tanks. The attitude of the Crown was that that sludge could also be discharged into the river at flood times. So at the time when the dilution effect was greatest, then that sludge could be discharged. So the consequence was you were still getting all the sewage going into the river. It's just that there was a time gap for when the sludge went through. But you had situations like that. That's not infrequent. Exactly the same was happening right up into the 1960s in Potiki.
You said
as an
that's
example.
the problem, but was there an alternative to doing that?
Yes, the alternative would be that you didn't have your sludge tank, your septic tank, on the riverbank. You could have put it further away. You could have had some filtration beds that you passed it through. You could create, in effect, filtration beds are in effect an artificial wetland. You could have done other mechanisms, but
Was that well known and understood?
yes, it would have been. But again, it comes back to the will of the local authorities and the cost to the local authorities. They were looking. When in terms of best practice, they're always measuring up the economic effects as opposed to the engineering effects.
So, in your view, that alternative approach would have been best practice at the time?
It might have been, yes. I don't know the circumstances, but I'm talking about it as the acceptable practice at the time, which was seen as better than doing nothing.
Thank you. Dr. Monty, will you be quite a while, or shall we start with Dr. Grant? Okay.
Kia ora, Mr. Alexander. Thank you very much for the report and your very informative and clear answers. Appreciate. I've really only left with a couple of questions. Page 16, where you discuss Crown and Māori understandings of the early Crown purchases. And I'll read the first sentence in one paragraph, third paragraph on page 16. It is not clear how well versed the Crown's purchase negotiators were in their understanding of English legal concepts or in explaining such matters to the sellers. And you would agree, of course, that they're explaining them in Māori, and so that the cultural language gap has to be negotiated, and vice versa when Māori are trying to understand English concepts.
Yes.
That pretty much like the treaty, the two different interpretations of what things mean.
Absolutely, and that's partly what I talk about here, is that it's actually gone, the understanding of the negotiations for those early purchases is beyond the scope of my report. You should actually rely on those historians who have looked at these purchases in more detail for a more definitive opinion about these matters.
The only other thing I wanted to ask you about was page 419, where you're talking about the Native Affairs Committee. Page 419 in paragraph 3. And you say in the last sentence, while Parliament was meticulous in cataloguing and determining a response to all petitions it received, the Native Affairs Committee's written record shows that the outcome of a petition was never communicated back to the petitioner. And I was surprised at that and wondered, is that actually correct? What period are you talking about? Because you do give us examples later on, Te Aputa I Hakara gets a response. Are you talking about an earlier period?
No, I'm talking about generally. If you look at those files, yes, there is a response in the sense that there is a resolution of passed by the Native Affairs Committee, which is the response to the petition. What I'm arguing is that the clerk of the committee has never written to the petitioner and said, this is the response that the committee has had to what you're saying.
Is that an assumption because the letter's not on the file, a copy of the letter?
There's no letter on the file, never on any of these Maori Affairs Committee files. So in effect it's left to, maybe it's left to the parliamentarian, the MP, to get back. But I don't know. It does not seem to me that there is any feedback loop back to the petitioner.
That is probably a good time to take the morning adjournment. Thank you. For 20 minutes.
Elder abuse in New Zealand is shockingly prevalent. The statistics show us that 1 in 10 people over the age of 65 will suffer abuse. And I have come across an elderly widow who has no family close by, and she's in a very bad situation. And your son comes in. Very soon he became very oppressive to her. He started taking over her finances, would take her benefit away from her, then demanded access to her bank account. She didn't have much, but he managed to deplete that, and then locked her in her room while he then rented out rooms to other people. This is not a situation that is extraordinary. These things happen a great deal of the time. I have a real concern at the present time, because obviously if this lady gets to that situation and there is nobody to step in for her to show her any alternatives, she can go to a doctor. Her agony is obviously enough that the doctor will say yes, and she can end her life within a few days before she's had the opportunity to have things turned around for her and for her family.
Takes 5 minutes, 55 seconds longer than your skincare regime. Maxibon, the 6-minute snack.
way. Me and you listen to the rain. Me and you, we are the same. Me and you have all the fame we need. Indeed, you and me, are we?
We're making banking easier so you can keep on moving with ANZ.
It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. You listen to music all day, so you want to listen offline and in the background, and without ads. No worries, that's all in the new music streaming app made by YouTube. Download the YouTube Music app and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
All right, we're ready to start again, and we have next Dr. Grant Phillipson.
Tēnā tātou, and kia ora to you, Mr. Alexander. But just before I start with my questions, I had a couple of other points. The first was to note that the Tribunal has discussed the issue of fitting in the Bassett report, and we've agreed that there is time to fit that into the next hearing week. And secondly, a question for you, Ms. Hall, whether the intention is to read the entire report tomorrow or bits of it. I'm not clear in my own head what's going to happen. So if you could clarify that, that helps me with my preparation.
The intention, sir, is to read it all. It is timed. It will be done. We will be able to get through it, especially as there is now time. So I would think we can clear it definitely very soon after lunch, if not before. We have 9 tribes, and each of the groups will take sections of the report and read parts. So it is the intention to read into it the whole report, including the opening summary, which is in their pages 1 to 13. The summary that we circulated yesterday is a speaking paper, but the intention is to read the summary that is in the report tomorrow.
Okay, thank you. That helps me with how to prepare.
Okay.
Thank you.
Thank you.
But we're not asking questions tomorrow?
No.
No. Great. Thank you, Ms. Hall. Now, Mr. Alexander.
Mum, I presume there's going to be a direction in relation to that Kay Bassett thing? I've been taken a little by surprise in terms of
Yes, we took into account your view, and
we
we can fit in the need for a summary and questions for clarification before the hearing. We've worked it out on our timetable, so there will be a post-hearing direction
with a timetable.
with
for
a
that.
timetable for it.
And will the hearing of it in week 3 involve cross-examination as well? Or are you just wanting, I think Ms. Hall mentioned yesterday about her just reading her summary, Mrs. Bassett reading her summary, but are you contemplating that all of the cross-examination of the report will also be done in hearing week 3?
Yes.
But with provision for questions in writing as well? Yes, after the event. And that should assist you, Ms. Cole. Fingers crossed. Thank you. Mr. Alexander, I just wanted to start by following up the question that was asked to you, the very last question asked to you by Mr. Morrison, in which he asked you whether Māori had pre-settlement constructed drainage works, and you responded by referring to the trenches that were dug to assist in the catching of eels. So I just want to clarify whether you really meant that those were drainage works, i.e. works prepared for the purpose of draining land.
No, not necessarily, no. That is not their purpose. They were there specifically for harvesting of tuna, but that was what I was talking about in terms of the technology that was available to Māori pre-1840. Would have been fairly limited, but it did allow some earthworks.
Yes, okay, thank you for that clarification. In your report, I want to start with a statement you've made on page 36. And I appreciate you were asked quite a lot of questions by Mr. Tanahu about the purchases, and I just want to clarify a point you've made. And it's at the very bottom of page 36, where you've said that the wording of purchase deeds can be a starting point for the consideration of the understandings held by each party to the transaction. And my question for you is whether that is in fact correct for the Rangatike Manawatu purchase. given the timing at which the deed was actually produced, the degree of uncertainty about the transaction, and the fact that that deed did not include any reserve provisions, so that Māori signing that deed, if they were aware of its contents, could in fact not have known what they were retaining.
Yes, I understand the difficulties, and that's part of the reason why I'm always saying that I defer to historians who have examined this purchase in more detail in terms of understanding the context of the purchase.
Yes, okay, thank you. In terms of the navigable rivers and the bed provisions in that 1903 Act, the Coal Mines Amendment Act, you've suggested on page 77 that the Crown was acting to embed the Mueller decision in section 14 of that Act, but you don't provide any evidence to support that. So I'm wondering, what is your evidence for that fact?
The evidence is the work that I did for the Ikawhenua Rivers inquiry. It showed that the Crown was taking legal advice at that time after the decision, and then shortly after, we don't know what that legal advice was, but the legal advice, shortly after the legal advice was taken, the amendment was tabled in Parliament.
So you've drawn that
connection? I've drawn the connection from the proximity of Mueller and the Taupiri coal mines with the passing of the 1903 Act.
I see. Are you able to provide that Ikawhenua research? It'll be on that record. Can you just give us a reference for it, and we'll
yes, I will do that.
Add that to our record. Thank you. On page 85, you've got a paragraph below the quotation there. And this is the Crown Solicitor's opinion, and I wonder if you could explain for me the statement, some limitations to the applicability of the riparian Crown grant. What does that mean?
This is in relation to the particular Crown grant at that point in the river that was being referred, that he had been asked to comment on.
And what were the limitations?
I'm trying to recall, but principally the limitations are that as to whether, if a grant has already been issued to a bit of riverbed or to land that has become riverbed, then that preempts the Crown's assertion of navigability and preempts its assertion of that land being vested. So that the issue of a title takes priority over the vesting.
Oh, I see. So
in the Crown.
So the grant was predated Section 14 of the 1903 Act.
Yes, yes.
Right.
Issued in the 19th century.
Yeah. Okay.
Having been issued, that has stronger status than the vesting power.
I see. Thank you. I understand that now. Page 126. You've got a statement there. Why did the Crown issue a licence to take gravel issued for the Otaki River and then expanded to cover all rivers in the Manawatu Catchment Board district? So did that mean that the Crown considered that the Otaki River and all rivers in that district were navigable? Is that the basis for extending that?
No, the basis, rather than making any judgment about navigability, the basis was to say that yes, the Crown had rights to the riverbed in the Otaki River.
Because it was considered navigable?
Because it had taken the land under the Public Works
Oh,
Act.
I see. It was a Public Works Act
Yes,
acquisition.
so it had become into the Crown's ownership via the Public Works Act.
Yeah.
So navigability was never an issue on the Otaki River. But it was then saying it was the licence to remove shingle over the whole of the Catchment Board's district was not for all riverbeds, it was for all riverbeds which the Crown could claim to own. So the Crown was only able to issue a licence if it was the owner of a riverbed. Otherwise, the Land Act didn't apply. The Land Act, the legislation under which the licence was issued, could only apply to lands which the Crown owned. So this was a catch-all just to catch up any situation where it might be that somewhere in the Manawatu Catchment Board's district there was a bit of riverbed which you could demonstrate was owned by the Crown, and therefore the Catchment Board was allowed to go ahead and extract gravel from it.
That sentence is ambiguous then.
I'm sorry,
It does need to clarify the point.
It needs to be clarified that it is solely for Crown-owned riverbeds.
Right. Which may or may not have existed.
Yes.
I see.
And the whole point of issuing that licence was that the Crown didn't have to go through the process of thinking whether it was Crown or not.
Could you rewrite that sentence? Just so that we capture exactly what you meant by that. That would be helpful. Thank you. This will all come in a direction, so you don't need to.
No,
to note it down.
To be prepared, though.
Yeah, thank you. Section 3.2, which covers a series of accretion cases. I'm not clear on what your argument is in that section, what we should take from that section.
Okay, the argument to take from that section is that the Native Land Court was acting on the understanding that ad medium film rights applied to native titled land.
Simple as that. Excellent, thank you. Just on that point, you talked about the 1941 inquiry with Ms. Brown, I think it was, that said, it referenced the validity of that presumption, and it is a presumption, back to customary and traditional ownership was the quote. So in light of that, is it an issue that Māori were not represented in that hearing and that there was no evidence from Māori at that hearing as to what customary and traditional ownership was?
It may be, yes. This was looking at the native land law and saying, regardless of this particular circumstance, if a native land court title had been issued, did presumptive rights to the centre of the river go with that native land court title?
Well then, can you look at page 152, which is your conclusion. And what you've said there in the second paragraph after the heading is that the court referenced the validity of the presumption back originally to the customary and traditional ownership. In other words, the court found that Māori under custom owned to the centre point, and therefore that's what the native land court title carried with it. So it's that prior step that I'm concerned about, the fact that the court made that without considering any customary evidence about what the custom actually was.
Yes, it did not receive any evidence, but it was just saying that it was understandable to Maori who had been brought up with custom that rights to the river went with rights to the bank.
So that's an assumption.
That was an assumption made by the court. Yes.
Right. Thank you.
So how can I put it? For want of a better way of explaining it, because the court had been applying the AMF principles in its previous practice, this was actually verifying and confirming that this was appropriate.
But I think this is the first time I've ever seen it stated so explicitly that the court considered it Māori custom.
Yes and no, because if you look at Judge Atchison's decision on Lake Omapari, that was exactly saying the same thing, that custom accepted that that the rights to the lake went with the rights to the surrounding.
Forgive me, that decision does not say that Māori owned to the centre point, therefore the lake would have been divided up into a cake, I believe.
Okay, I stand corrected on that.
Yeah, thank you. There's page 167. And I should add, I'm going to put some questions in writing as well, but these are just points I wanted to discuss with you. The second last paragraph on that page, and this is particular to the River Boards Act of 1908, you've said vested in a river board those property rights in a riverbed that were necessary to the carrying out of its duties as a river board. Can you explain to me what those were, those property rights? That's a very odd way of defining property rights.
Yes, well, I think I'd have to ask you to refer specifically to those sections to read those sections in the light of the legislation there. But my understanding was that the River Board was given rights to undertake certain activities within a riverbed, and these rights to do that work were notwithstanding any other land titles law rights that might exist.
And that was considered, is this your wording, vested in the board property rights, or is that in the legislation?
I can't recall.
Okay, thank you. Moving forward to pages 210 to 11. The approval of subsidies under the Soil Conservation and River Control Act, it's not clear in my mind, and you mentioned earlier in your answer the role of Treasury, it's not clear in my mind whether the Soil Conservation and Rivers Control Council could simply approve subsidies or whether it recommended to the Crown that subsidies be approved, depending on whether Treasury would agree that the money could be spent. So can you clarify that? I originally thought that council just approved them, but now I have doubts after reading your report.
I'm not entirely confident with the reply I'm about to give, but I believe that initially when the Soil Conservation and Rivers Control Council was established, its authority, it did not have delegated authority to decide on these matters. Therefore, it recommended them, and the matter went to Cabinet, and Cabinet decided, but Cabinet inevitably received a Treasury briefing about that. As time went on, a delegation was issued to the Council, so that it was not necessary to go to Cabinet to get a Cabinet approval. and the council could issue its own approval at that time, as long as it was presumably complying with certain criteria which had been established either by Cabinet or by Treasury or what.
And is the same true of the authority established in 1967, that it had a delegation to approve subsidies?
Now, that's different. The Soil Conservation and Rivers Control Council was its activities were brought into a Water Resources Council.
Yes. And that was soon abolished, wasn't it?
That was soon abolished, but
yes.
Yes. I think by then the delegation was an established practice,
right.
And therefore it was with that passing of the legislation in 1967, there was no need to go to Cabinet or to go to Treasury. As long as the funds had been provided by Treasury and Cabinet to the Council, then it could distribute them, subject to the criteria. In practice, it could distribute them as it wished.
Right, okay, thank you, that's helpful. Sections 5.4.1 and 5.5.1 of your report, you don't need to go there, but I'm just wondering, all those flood protection works that you talked about in terms of the Manawatu River, what effect did the flood protection works have on the ability of Māori to obtain resources from the river, their traditional resources? Putting aside the issue of access, I'm wondering what effect the flood protection works themselves had, deepening the channel and all of those things, on the ability to get traditional food and other resources. If you don't know, that's fine, but do you know?
I don't know, but what I'm coming around to saying is that I believe that the lower reaches of the Manawatu River, which were most particularly affected by flood control schemes, so that's effectively from the Aroa River downstream, the amount of Maori-owned land on the riverbanks had declined considerably. There was very little riverbank land still in Maori ownership. Mm-hmm. So that while it's possible that Maori were using that waterway for harvesting, and that is certainly shown in my chapter on fisheries in relation to inanga and so on, to the whitebait, mm-hmm. that it is of value to them. But there are consequences for that, but I don't know if I can answer it in any more detail than that.
Okay, thank you. Turning to page 432. At the bottom paragraph, you've said that this indicates that by the turn of the century there was no locally held conception of exclusive hapu sovereignty over estuarine fisheries. I think that's an awfully large conclusion to draw on the basis of 2 Māori names in a petition, which seems to be the foundation for it. So, what's your response to that?
What I'm trying to show with the large number of Europeans who were petitioners was that they were fishers in that area, just as Maori were. So therefore, there was no exclusivity that hapu could have in terms of the fishery at that point.
So, how does that second sentence fit with the first one there in that paragraph then? Is that not what you actually intended to say?
No, what I'm trying to say is that it had become established on the ground that both Pākehā and Māori could fish in that area. And
I see. I understood that Yeah, okay, I understood that differently, but thank you for clarifying that.
Yeah.
And just one final question, and I'll put the rest in writing, is to take you back to one of the questions the Crown asked about your statement on page 153, which is about that the gains for the Crown from taking that approach were strictly limited and did not deserve to be overemphasised. This is about the assertions of ownership of navigable riverbeds without testing them in the courts.
Yes.
Conversely, did that leave Māori in limbo? The fact that the Crown could at any time assert an ownership right over a bed, but those assertions were never tested in a court. What I'm suggesting is that there was no process by which Māori could prove otherwise if it's never tested in a court.
Well, that's correct, but yeah, the Crown was using its assertion as in effect a trump card.
Yes.
To say that.
Sorry to interrupt, but wouldn't, and Dr. Grant, you've written about this, wouldn't it be the case they could always take a matter to court?
What I'm suggesting...
I'm just not understanding.
My point is that the Coal Mines Act, 1903, establishes well, it states that the beds of navigable rivers are vested in the Crown, and the question of, leaving aside the question of to what extent parts of a bed were navigable, that act didn't provide any process through which Māori could, say for example, a commission or any other process other than litigation in the very expensive courts, High Court and or Supreme Court as it was then, and then the Court of Appeal, for that the question of whether a bed was navigable and therefore in the ownership of the Crown to be established. So it's just there. And whenever the Crown wants to, it can, for example, when jet boats were invented, making thereby a river more navigable than it was before, the Crown can assert at any time that that bed belongs to the Crown, but there's no process by which Māori can establish that it's not navigable unless the Crown both A, makes an assertion, and B, takes that assertion to a court to determine one way or the other. That's the point I'm trying to get at, so that even though you're saying that the gains for the Crown from taking the approach that it did was strictly limited and don't deserve to be overemphasised, I'm saying that there's a converse to that in terms of what Māori could and couldn't do. Am I making that point clear, or is that still obscure to you, Judge?
No, I'm clear now.
You're clear? Mr. Alexander, do you have a comment?
Yes. When I talk about not deserving to be overemphasised, I'm saying that it is only an assertion. It is not an established feature of law as applied to any particular riverbed. Having said that, the authority that the Crown has when it makes that assertion, puts the onus on other people to argue against it. The Crown, that was the Crown's approach. It never wanted to go into court and argue its case. It just wanted to assert it and leave it to others to argue against it. And that was a high barrier to that assertion being challenged.
Yes, and so in the case, the other case that you talked about, where all rivers could potentially have, through that decision that was made, not just the Otaki River, but all of them in the district, if there happened to be a bit that the Crown later claimed it owned, it could then take the gravel through that process. That's a similar situation.
Yes, it was a catch-all for,
Yeah. Yeah.
which meant that the catchment board didn't have to go cap in hand to the Crown every single time it wanted to know whether the Crown owned the river or not.
Right.
It was able to say, okay, we've got this licence, we can carry on with our activities and without interference.
Yes, okay. And that obviously will need some further thought. So thank you very much for your report, Mr. Alexander. I said yesterday, in conjunction with the others we've received, all three have covered different areas, and it's very helpful. Thank you.
Sure.
Ms. Simpson? Tēnā koe, Mr. Alexander, and I also like to thank you for the work that's gone into this report and the benefit of your considerable experience in this field. Just on the top of your page 416 of your main report,
Yes.
You've given a view there, and if I paraphrase it, it's around the Crown's responsibility to actively protect the interests of the treaty partner, and in respect of protecting the quality of waters, that it's failed in its governance task. And you also go on to say, failed to respond to Māori kaupapa and institute measures of central importance to the tikanga of tangata whenua. Do you consider that Māori are more likely than non-Māori to be affected by the quality of the waterways?
Yes, I do, because I believe that goes to the heart of Māori, the life force of those waterways.
So given that government and local government have effectively the control of activities along those waterways, do you consider that the authorities have an obligation to keep Māori informed about the quality of the water in those waterways?
Yes, I do. I believe that it's an obligation to all New Zealanders, in fact, but in particular to Māori, because they have that kaitiaki responsibility for each and every stretch of waterway.
And as Māori were swimming, drinking and eating from those waterways, that obligation would be important. And I just wondered, in your research, did you come across much evidence of that communication from the authorities to Māori about the impact of the quality of the water and therefore the impact on human health?
No, there was not, and that comes back to the absence of references to treaty obligations in the legislation. And when the statute doesn't require things, then government officials don't think they have to do anything about that sort of thing. So we've had that right through, up until the RMA was the first time we're getting Māori references in statute. And then before then there wasn't, and therefore the local authorities, the Crown, never felt any obligation to consider the interests of Māori specifically.
Okay, that's all from me. Thank you very much. Ngā mihi.
Thank you, and I'm sure you've just forgotten about the Town and Country Planning Act provision.
Yes, I have just forgotten about that.
Yes.
but
you know about it, so I'm not.
Yes.
I mean, I just wanted to help you clarify that.
Thank you. That came in 1977. Yes.
All right. Do we have a standard lease agreement that was used by the Land Board at the time that the case study that you refer to on page 70 was was happening?
No, I'm afraid I haven't examined any of the lease documents. Yes, the Aotea Māori Land Board probably had a standard template for its lease, but I don't know what that said. But likewise, I don't know to what degree the Aotea Māori Land Board operated within the inquiry district. No, it operated more, quite a lot more in the Whanganui district than it did in this Manawatu district.
Okay.
I don't know.
Thank you. Now, in terms of Chapter 5 and 6, and it's the old issue of consultation, you refer there to Section 36A and the fact that the RMA states that there's no duty to consult with respect to resource consents and notices of requirements. What is your view about that? Should it be amended or repealed because it doesn't require that?
I think that's a deficiency in the legislation. I think that again it comes back to the basic status of Maori in the RMA process. At the moment, they are not central to the process because the legislation is written as though sole authority resides with the Crown and with its delegated regional councils. So until that is addressed, I can't see that the subsequent issues relating to Maori involvement can properly be addressed either.
And just staying with those two chapters, chapters 5 and 6, the resource management case study aspects of the mostly sewage treatment plants issues. Those case studies suggest a high degree of collaboration between the regional and district councils to essentially avoid dealing with Māori until it's too late for any significant change to be made to any application for a resource consent. Would you agree? Is that what your work suggests?
Yes, that is probably correct. Matters had largely been, I won't say settled, but the direction of travel had largely been set up prior to any resource consent hearing. So you have the officers' reports come in. They are in a certain direction of travel. You have the applicants' reports come in also in relation to a certain direction of travel, which is set by the rules of the planning rules, but is also set by the circumstances of each particular case. Having set that up, the argument at the resource consent hearings is quite limited because of the circumstances that apply.
What's your view of the importance or otherwise of the cultural impact studies that are usually done with major resource consent applications?
I think that sometimes they are compromised by the nature of the process. They can say that, for instance, with these discharge of human wastes, obviously a cultural impact assessment will say we do not want to see any discharge at all. But if that is all they say, then they almost certainly get discounted from the consideration, because the consideration is how can we allow some discharge which still meets cultural sensitivities. And if the cultural impact assessment says there is no way you can have any discharge, then they've been taken out of the conversation. So it is actually quite difficult. You can have these cultural impact assessments, but unless they are embedded in the regional policy statements, they are embedded in the planning rules, then you will not get any traction with them.
Right, and I think you made reference to the fact that the issue of human waste being in waterways was offensive to Māori is already covered in the one plan.
Yes, but it is covered, but with a let-out clause. So the principle is established, but there is some wriggle room to allow consents to be issued which are in effect changing towards that principle, reaching that principle.
Thank you. All right, those are all my questions. Are there any? No, thank you. Well, Mr. Alexander, again, I can't thank you enough both for the assistance you provided for today and yesterday and the report you've provided, but also for the work you did on the rangiteke, which we're going to be able to draw on for this inquiry district as well. So thank you so much.
Oh, kia ora.
Just talking about the RMA, I went back and had a look at the amendment for 2020, and I see that the provision I was discussing had been removed. No, 2020 amendment to the Resource Management Act. There was, it must have been removed at select committee or a committee of the whole stage.
Oh, that it was in. So you were referring to something in relation to the fast track procedure?
Yes, there was a treaty provision in the bill,
right,
which I had seen,
right,
and it's obviously been removed.
Oh,
so when you give us an update, I'd like to know how that was removed
and what happened. Right.
and why. Thank you. Me karangāti wau ki a koe Pirupi, ko tau mai a Pirupi Wk. Te māngai o te iwi o Raukawa mō tēnei wā.
Who represents
Ngā mihi ki a koe, mai I a mātai.
Greetings, sir. And it's on behalf of Excellence.
And I think you're being led by Mr. Rogers. Thank you.
Ma'am, before Mr. Rogers begins, we have no questions for this witness, so can we please seek leave to withdraw at this point?
Leave granted. Thank you, Mr.
Thank you, ma'am.
Dr. Gilling.
Also, ma'am, Mr. Lewis here, may I seek leave to withdraw at the break for the remainder of the week?
Ma'am, while we're on this kaupapa, could I also seek leave to withdraw at the break, and Ms. Martinez will continue for the remainder of the hearing week?
Yes, fine. You shouldn't take that as an indication about the quality of your work, Mr. Walker. It just means it's so clear they have no questions of you. All right, Mr. Rogers.
Tēnā koe mātua Pirupi, ka noi te mihi atu ki a koe.
Sir Pirupi, please sit.
Kia koe nā tō mātou tari, ki a koe ki tō pūkinga hoki.
And of course
Kua
your dedication.
takoto koe te manua roatanga o Ngāti Raukawa I tō tuhinga. And I had to observe in your report as well your long-standing involvement. Your own long-standing involvement with this kaupapa, seeing a wonderful photograph of you and the staff of Te Upoko Tika Radio in the 80s, and here you are standing and delivering this kōrero again now. Ka noi te mihi ki tō mahi roa e hoa.
Certainly isn't.
So you are the author of Part 3 of He Te Ngā Mōtai, the Oral and Traditional History Report. That's on the record of inquiry as H1, if that's correct. Ka pai. And you have acknowledged as well that Tā Tai Hākure Jury has contributed Chapter 5 to your section of that report. Kei te pai. And you've prepared a summary of the report, which is on the record of inquiry as H1 in brackets C.
Yes, I have.
Ka pai. And I understand as well that in response to a question from the tribunal relating to the structure, the methodology, the intent Hēti Ngā Mōtai taken as a whole, that you've prepared a response to the question posed in earlier memorandum directions. But perhaps it's best to deliver that particular statement when we come to the Tribunal's questions, Your Honour. Ka pai.
Can I just ask then, who is actually answering questions about Chapter 5, which wasn't authored by Mr. Walker?
I'm sure if he can't answer them, he'll tell us who the appropriate author is.
Well, it was Tai Hakare.
Yeah, and he's coming tomorrow, so...
I have 2 questions in relation to Chapter 5. I assumed they would have to be dealt with later, but...
Well, put them to
I
Mr.
can put
Walker,
them to
because
Mr. Walker.
he may be
Yes.
able to answer.
Yep, sure.
Sorry,
I would prefer it, ma'am, if Tai Hakure answered the questions on Chapter 5, because it is a very complicated set of history, the evolution of the Māori councils, and he is an expert on it. It is clear.
Mr. Rogers?
Ngā mihi, sorry, I'm having some...
So are you going to organise that?
Oh, okay, te pai
All
mai.
right, thank you.
Well, that's me out of the way, e hoa. I'll leave it to you to mihi, introduce yourself and to present the summary of your report.
E anō, hei te whare atu nei, i tēnei o ngā takiwā o tūpoko teik e mihi ana. Te whare papuri ngā taonga nunui o ngā iwi o te motu. O ngā whare whakairo, te hau ki tūranga, rongo marairoa, kora o tātou pakeke. He tūpato, kaua e toe o tātou mate. I roti ngā whare o tauwi. Me waihono mō tātou mara. Engari, taku te tiro, taku whakaroa ki tēnei ata. He whare kākano rua tēnei. Nā wawata huirangi, ki haere tahi te reo Māori me te reo Pākehā. Ka hau mai ki roto, ka ki te reo Māori e. E ngangahu mai ana. Te taho ngā pau o te whare ko te reo Māori. Ko ngā kaimahi, ko ngā huatanga. O reira kei te arohātu ki a tātou. Ki ngā mate maho te wā, he maha lawa ki te whakahuahua ake. Engari kei te tautoko, me te aroha nui anō ki a huhana i nahi, te puna roi mata. Ki o tātou kaumātua ngaro i te tirohanga kanoi. I eni rā kei te aroha te motu katoa, ki te whānau Raukawa, te kaukauroa pāta tere, te whānau te hiko. Rātau, e te hitaia ki e rā mate, te tokorua i mate i roti te ahuatanga o tēnei mate. O ira kei te mihi kia tātou katoa i roti ngā ahuatanga o te pakanga ki te mate nui, e karapoti nei i te ao, i te tangata. E whakamataku nei i te iwi, kia kau e hala mai ki ngā ahuatanga nei. Wa reira e te kai whakawākei te aroha ki a tātou katoa. Ai te hoki ngā mahara ki a Tai Hakure i Waitara. Te marama waru te kau mātai. Te kare mea a eila i taua. O te whakatau, o te rūnanga. Kia tū i rungi te marae, tua tai. Kia haere ko te reo Māori tua rua. Kia noho tata mai ngā pakeke i te taho ngā kai whakawātua toru. Tua whā, kia kau e wero he te tangata e te roia. Koe rā ngā ture i taua. Aina ko te whakaaro ake, he ture pai katoa hoki era. Ana ka tai mai tātou ki tēnei rā, ki te runa whakawāo waitangi, te rōpu whakamana e mihian. E mihian e kia koutou katoa ki ngā kai whakawā, o tauke, kia Paul Tem, kia rea maratima, rātou. Mikaele Sorensen, Peter Chapsky, ana e te heo rātou e te oraton, o e tahi kua ngaro i te tirohanga kanai. E ka nui te aloha ki a koutou, he tautoko ana. I a koutou mahi nui, te tīmatanga o tēnei whakawā, i te ora iwi kātea. Me ana wawata nui, Ngāna te ki, i roti te wai 113. Tā mātou kia pai herea, ngā mahi katoa, mea mātou whakaaro, kia aia ki tō tātou kaihang, i runga no i te mōhio, tērā te whakatau ki ka uihia mai nei e rangi tāne o tira e pēti te awe awe. Ko te manawa roatanga o Ngāti Raukawa ki te papuru i te rangi Mārie, arā i te whakapona. Koera ngā whakaaro o ngā pakaki, mo te whānui tangātu o te ao i a rātou, te ao i whānau mai ai tēnei tuhinga iti, nā ngā pakeka hau i unga, i tono, ke tui tui. Tā iwi kā tea ko ene ngā tauira i whakatauira tia mai nei, mai iho. Nō reira koutou te hunga wairua kia koutou, tātou ngā waihotanga kia tātou, i roti i tēnei ao hau, me ene whakatipuranga e haereake nei. Tēnei rā te mihi atu nei kia koutou rauranga tira mā. Koutou te whakaminenga e koro tia nei o te tarai piunana o Waitangi. E noho nei ki te wānanga i ngā take o te iwi Māori. I roti i tēnei ao hau, ao rereke, tēnei rā te reo o Ngāti Raukawa ki te tonga. E mihi atu nei, e tangi atu nei kia koutou. Mā koutou ene o mātou kupu e te tiro, ka kia ke au a Ngāti Raukawa mo tēnei koroa mātou, e hara nō nāia nei, nō na nahi tonu nei, me ki, nō tua whakarere, mai rā nō, nā o mātou tupuna tukuiho. Kia whakahoti atu, i runga no i tēnei whakaaro me te tūmana. Mā te atu koutou manaki e tiaki, i roti ieni mahi nui, e pīkau tia nei e kawea mai nā e koutou. Tēnā koutou, tēnā koutou, tēnā koutou. Hui rā te hohonu te ngātu, o ngā whakaaro, te kākano, te māla whakatupu-tupu i ngā kōrero. Ka whakatakotungia e te iwi i roti ngā rā e tūmaini. O re mihi ake ana kia koutou. Tērā te whakatau kia o tātou pakeki. Whakapapa uia, tau reka reka. Hei anō. Hei uri hau no hape ki tuarangi. Rāu ko te ākau. Ka mate hape ki tuarangi. Ka moe a te ākau i te tarupraha. A whānau mai, te pēpea hape rāua ko te ākau. Ko pipi, koe rata ko tupuna ko ia. Heke mai, kia heimi wālai. Ko rongo koutou i tērā ingoe tēnei wiki, James Howard Wallace. Hei uri hau no tērā tangata. Hei no he whakātu atu. E ki ana ngā kōrero, e uia mai koe ngā whenua nei atama. E māwe ki atu, nā mea, ki mōhunga. Ko wai tēnei tū atu nei. Ngāti huia, ngāti kopere. Ko reira tānia, o tātou hei mihi ngā kei tēnei rā, ko Ngāti Brau e noho nei. Te piringa mai o Ngāti Brau ki roto o Raukawa, ko tō koutou kaumātua, ko Weremu Pāka. Ko Weremu Pāka te tangata nāna, a pare waha, whare i whakatū. Hui ni te mihi aroha kia koutou, e mahi nei ngā mahi whapai. Tīmata mai i te koroua, nā i rongo au i te vai a te i te rātua tahi, kāti rā e koro te takota i rarora. Nā, a pātu ki te aroha te ki te ia koutou. Grant, ko tāua e hoa, kei te kahatonu koe, te puna o te mōhio, o tira o te aroha, ki eni o ngā kaupapa. I pahore tō tuara i roti ngā tau, e hoa, kua tai koroua tia koe i nai ane. Wena kei te haere tonu ngā mai. Ana ko te tino tangata hei mihi ngā ke Conrad, hei te tangi te ngā kau te kiti āku i roti i tēnā pauaka. Te tūmana kei te pai kei te hau tōno hi rota. E mihi ki a koe tūhoi maumau kai, maumau tonga, maumau tangata ki te pō. Te iwi kahalawa ki te whakāku i te motu ki te kōrero Māori. Tō iwi o ngai tūhoi, koe ni te awa, ka ki te i a koe, ka hoki ngā mā. O ti rā ki ngā roe no maini, ki ngā kaimahi o te tribunal. He wāhi nui te wāhi ki koutou katoa. Angareira, i roti e ni pito whakaaro, me huri ki ngā mahi me te kaupapa. Kia ora tātou. a tribunal aware that I've been involved in these hearings and in a different role in earlier times as your interpreter. In sequences of the tribunal hearings where the language flowed freely and tangata whenua and hapu placed kōrero tukuiho before you. At a certain point in the history and life of these hearings, kaumātua Ngāti Raukawa came to see me and asked me to consider researching and writing a part of an oral and traditional history report. It was an unexpected tono, but it didn't take much reflection for me to agree. I felt aroha for our kaumātua. The amazing story of Whakatupuranga Ruamano, led by Whatarangi Winiata. The struggle to re-establish the iwi and revitalise the marae, to re-enculturate the young and to produce a new bilingual generation was an exhausting task. But alongside that, sitting in all of those kaumātua's breast was their sacred duty to carry to the conclusion that was required of the ancient claims for justice of their tupuna. And there they were in their great age. Not great age. The critical age is 70. That's about the age where you might think te ao Māori you can retire. My experience of them is that 14-year, 15-year period after that was the busiest time of their lives. Their duty to the iwi activity and to the hapu activity, and then alongside that came the arrival of the tribunal claim, long awaited. So I felt it was a duty of the younger ones, although I wasn't young, to assist, with very few qualifications. There are 4 parts to this report, and I'm the third. The first is by Dr. Ardini Loda. Dr. Ardini Loda. The origins and establishment of Ngāti Raukawa Te Auki Te Tonga. The second are the Hapu Oral Narratives Report, introduction, which will be presented by Hapu in due course. The third is this report, part 3 of the report, called the Oral and the Establishment of the Social and Cultural Institutions of Ngāti Raukawa Ki Te Tonga in the 19th to the 21st century. And the fourth is a section on rangatiratanga, on the Māori view of the intact systems of governance which were attacked and undermined at colonisation, jointly written by Ani Mikaere and Whatarangi Winiata, which will also be presented to you in due course. Paragraph 1. This is the summary I'm reading. This report deals with the establishment of the institutions of the modern Ngāti Raukawa, Ngāti Kaupata, and Te Reo people of the southern west coast of the North Island, from the time of their arrival in the Cook Strait, Manawatu, Rangitike region until 2010. The institutions we chose were the Māori ancestral religion, Rangiatea and the churches created by the early Christian conversion, the Otaki and Porirua Trusts boards, which were formerly separate trusts, Raukawa Marae and the Raukawa Marae trustees, noting that will be presented and discussed in detail by the Hapu of Otaki when the hearing moves there. The Otaki Māori Racing Club, the Raukawa District Māori Executive, which became the Raukawa District Māori Council, Whakatupuranga Ruamano, Te Wānanga o Raukawa, radio and television, the radio station Te Reo o Raukawa, the radio station Tūpoko Tika, mentioned just now, and the radio spectrum, the Māori Women's Welfare League, and then Te Runanga o Raukawa and its subsidiaries. In general, this narrative does not focus on the single most influential and cherished institution in the life of hapu and whānau Māori, the ancestral marae. This is because a report produced by those hapu has been presented as part 2, constructed by hapu writers themselves. They are the ones who should write about the history of their own marae and indeed their own hapu, their own kāwai and their own whānau. It does not, there are only 2 exceptions. One is the main marae matua in Otaki, Raukawa. Although it is the marae of the hapu of Otaki, it appears in the story because all of the iwi like to call it home, a marae matua. The Raukawa Marae Trustees, the Pan Hapu and iwi body established in 1936, administers it. So some discussion of the marae appears in Chapter 4 on the marae and the Raukawa Trustees. Likewise, in order to do justice to that part of the Whakatipuranga Ruamano program, a short summary of marae rebuilding projects over the 25 years, 75 to 2000, across the iwi appears in Chapter 7. The establishment of Rangiatea Church required significant planning, man and woman power and resources. It spanned the signing of the Treaty of Waitangi, the arrival of newcomers, the Pākehā in numbers in Cook Strait, and the conversion to Christianity. In the face of the new economy, an imposed rule brought by Pākehā to Aotearoa, Ngāti Raukawa showed determination and flexibility. There are 10 institutions featured in the report. The later ones were part of the modern era, when Māori had acquired Western education and been influenced by the modern world and deeply affected by colonisation. The most recent institutions, Whakatipuranga Ruamano, Te Wānanga o Raukawa and Te Runanga o Raukawa, can best be described as part of a self-correction to recalibrate the iwi and to recover mana, to repropagate identity, educate the individual and ensure economic capacity. In the period 1825 to 1830, Raukawa people migrated at the invitation of Waitohi, the sister of Te Rauparaha, and established themselves in the Rangitike, Manawatu and Horowhenua areas. Prior to 1826, Ngāti Raukawa were an ancient Tainui canoe people in their home base in the Waikato. We inherited a rich ancestral religion and a magnificent legacy from our Pacific voyaging ancestors and the 700 or so years of history in the Waikato. From the time of the Battle of Te Mangeo led by Piko Te Rangi, the battle was later called Hingakaka. The battle was later called Hingakaka, which took place around 1768. Ngāti Raukawa and Ngāti Tōrangatira spent 50 years in nearly continuous active warfare. These wars began with wars against our relations in the Waikato and elsewhere, and ended with contest with non-Māori. They covered 4 major periods of conflict. The first 3 were the wars in the Waikato, and in fact, they had been going before that, the campaigns of Hapika Tuarangi and others. There were the wars of attempted conquest in the Hawke's Bay. There was internecine war with our migratory allies in the Horowhenua. The 4th involved sections of Ngāti Toa against settlers and Pākehā troops in the Wellington region in the 1840s. All iwi then found themselves deeply affected by a 5th set of wars, the land wars, being fought not far away in Taranaki and elsewhere, with some Ngāti Raukawa participation from 1860 to 1878 and their later consequences. The primary focus of the pre-treaty period before 1840 in this report is on the ancestral belief system, the origins of the desire on the many to convert to Christianity, the establishment of the Church Rangiatea, and the West Coast Catholic Mission as central iwi institutions. After 1840, the iwi, for the most part, adopted Christianity. They had established a major trading, political and military empire alongside their Ngāti Toa and Taranaki allies from 1820 on Cook Strait. This enterprise was maintained through to 1859, backed by force of arms, diplomacy and strategic marriages, and clever recruitment of talent and resources. The iwi encountered Christianity and sent for missionaries to come among them. They grappled with the upending of the Māori worldview brought by Christian conversion, the instruction in new spiritual practices, and the rules of their new teachers. Te Rauparaha ordered the building of Rangiatea Church in 1848. Rangiatea Church has been a major institution in the life of the iwi through the 19th and 20th centuries, down to its rebuilding after the 1996 fire. The iwi welcomed the arrival of the first settlers. They made adaptations to how they lived to create a new economy, new trading enterprises, and to modernise and improve living conditions. The people enjoyed the flowering of the Māori economy in the years to 1859 and played a major role in the creation of Otaki Township and later Foxton and other towns. Later in the 19th century, after the reverses of ravaging diseases, the land wars, the arrival of the Māori Land Court, and forced land sales, population decline and poverty. The three iwi confederation, including Ngāti Raukawa, found themselves in a marginalised position, battling for biological and cultural survival. In 1936, the people, in concert with Parliament through an Act of the Crown, established the Raukawa Marae Trustees to create a representative three iwi body and to act as owners and guardians in perpetuity of the new Wharenui Raukawa in Otaki. The rebuilt meeting house was opened that year. Within the Act were sufficient powers and membership of sufficient weight in Māori terms to create a runanga for the three iwi confederation, Te Atiawa, Ngāti Toa Rangatira and Ngāti Raukawa. In the 1970s, this body engaged in an incredible burst of iwi redevelopment called Whakatupuranga Ruamano, which was comparable to the campaigns of the early 1800s in intensity and passion. Chapters 3, the Otaki Porirua Trust Board, 7, on Whakatupuranga Ruamano, and 8, Te Wānanga o Raukawa of this report focus on education. The iwi and its leaders, alongside Ngāti Toa, played a part in the 1847 Whitireia College proposal. They actively supported the Otaki schools in the 1840s to the 60s and the establishment of the Otaki Māori Mission College in Otaki from the 1880s. From the earliest gift and transactions in relation to the land at Whitireia and Porirua, the iwi was always interested in the Church Mission Trust at Whitireia. The land there was given after decisions of Ngāti Toa Rangatira, with some input from Ngāti Raukawa leaders, for a school which was never built. The original Porirua Trust eventually became the Otaki and Porirua Trusts Board under an Act of Parliament in 1943. For decades, iwi felt like spectators in the affairs of the board. In recent years, it has once again become an iwi affair. The iwi has established or partnered the establishment of other social and political institutions over the generations. Chapter 5 of the report provides a history of the Raukawa District Māori Executive and the modern Raukawa District Māori Council, kindly contributed by Sir Edward Taihakure Jury. I'm very grateful to him for this chapter. He described the Raukawa District Māori Council, which is a corporate entity under the Māori Community Development Act 1962. It promotes Māori community development, advocates for Māori in the districts of Manawatu and Horowhenua, and contributes to national policy development through the New Zealand Māori Council. It sits within a structure comprised of committees, usually marae committees, district councils, and the New Zealand Māori Council. There is also provision for executives to sit between the committee and the district council. Only one district maintains executives at present. Historically, the district council is focused on marae, papakainga, and urban migration, and at the national level on rights and natural resources. The Raukawa District Council is part of a statutory scheme with the New Zealand Māori Council at its apex to provide for Māori self-government. In practice, the New Zealand Māori Council is an advocacy body. The issue is how this fits with the principle of rangatiratanga in the Treaty of Waitangi and how this principle could be applied better. With Pākehā settlement, Māori sought to adopt, adapt and improve on Western systems to strengthen their political and economic capacity. They also sought pan-tribal unity to withstand the influx of settlers and apparatus of imperial government. From that search came the kingitanga, te kotahitanga and independent religious movements. For Ngāti Raukawa of the Raukawa district, the kingitanga had special significance because of their tainui whakapapa. They supported the king's motto of Mana Māori Motuhake and his stand for self-government. To keep community discipline without the use of force, and to exclude the governor's magistrates, administrators and constabulary, the king introduced runanga, karere and watene. These, now called councils, community officers and wardens, became the operatives of the Māori council system established by statute in 1962. Among the wartime issues, that is World War II, the council dealt with were proposals that the Māori battalion should serve in the Middle East in preference to the Pacific. The council asked for consideration of reports on prospective recruits, consideration of reports on Māori committee fundraising, and those returned to New Zealand on furlough should not be returned to active service. Other proposals contained pleas that sons and grandsons should be returned from the war when they had served as much as 4 years. The council asked for restrictions on tohemanga, a local word for toheroa, and birding for the supply of food parcels. And Tai Hakure describes the civil issues the council considered. In respect of inadequate workplace conditions, especially for women and minors in market gardening in Otaki and Opiki, the council complained of unsatisfactory housing for some 500 market gardeners at Opiki. Likewise, the poor at several papakainga included overcrowded one-room whare. Reports from district nurses described Māori housing and drainage throughout Manawatu and Horowhenua as, quote, appalling and, quote, shocking. The council discussed condemning of homes in papakainga and requiring Māori to move to town to rebuild. Impossible conditions for rebuilding in rural papakainga, for example, sole ownership of land and roads one chain wide. They also led opposition to government requirements for Māori to give over Māori land in town areas for state housing, not exclusively for Māori, such as the Titoki block in Otaki, and to supply timber from Māori land in the Ranges. Apprenticeship and trade training was needed. Otaki College was proposed for plumbing and bricklaying. Scholarships, the council pointed out, were needed for attendance at Māori schools. They asked for Māori language to be taught in homes through the radio. Council were concerned that illegitimate children born in cities without grandparents' knowledge. Māori guest houses and hostels were needed for the young people moving to the cities. A proposal was floated for a Māori community centre for Palmerston North. Pākehā were building groins on their side of the Rangitike River, causing the river to erode the Māori side, and others were then putting up stone crushers on the eroded lands. The council felt its post-war tasks should not be just the rehabilitation of the returned soldiers, but the reconstruction of the people. The average Māori had nothing. The council said, the land having disappeared extensively. And my thanks to Tai Hakure for that chapter. Raukawa established the Otaki Māori Racing Club from the 1850s. It's chapter 6. This club grew naturally out of Māori and Pākehā making contact with each other and growing to enjoy each other's pastimes. Horses arrived very early along with all other livestock and hapu of the coast, their members in Tamariki becoming good horsewomen and stockwomen. And I would mention also the arrival of the coach system, which is dealt with in the oral history section of my report. Uncle Martin's recollections of the river crossings, the horse changes and the stables was also part of the increasing knowledge of horsemanship in the area. Races were run very early, as was betting. Early race tracks in the vicinity of Katihiku on the south bank of the river and Otaki town, and indeed race running into town, are recorded from 1854, with regular full race meetings from the 1860s. Beyond its obvious attraction as a recreation and sport, it has provided employment and opportunities in the racing industry. It is also a place where the iwi and those associated with the club have been able to offer hospitality and attract and look after manuhiri, a cardinal Raukawa aim and indeed a Māori virtue. The racing club is regarded to this day as a taonga tukuiho. Hence the loyalties and efforts of iwi members in that direction to ensure its continuance and uphold its mana. Whakatipuranga Ruamanu, the 25-year program of cultural and political revival of the iwi in 1975, developed and led by Whatarangi Winiata. With his supporters, approved by the Raukawa trustees, was a signal development. It was the largest initiative launched by the three iwi in the 20th century and the one with the widest consequences for change. Its planning, its establishment and activities are described in that chapter. It was Whatarangi's dream to refocus iwi activities on the people rather than just buildings, to redevelop marae, to revive the Māori language. A serious, real revival. And to seek greater control by Māori over their own affairs. Te mana Māori motuhake. Through its activities, the three participating iwi sought to modernise further, but not abandon whanaungatanga, the core values of closeness and loyalty to one's own relatives within the kin group. Through the remarkable efforts of this program from 1976 on, the marae is the main gathering place operating within tikanga Māori, and the use of the Māori language moved once again to the front of the loyalties of the young. Marae and their facilities saw widespread revival, and the teams to crew them expanded considerably. This was in fact the goal of the program. Buildings, yes, but people must be the most important focus of all activity. The branch of activity called Pākehā Mission, which taught non-Māori about Māori culture and aspirations in an attempt to penetrate Pākehā society. This is a Whatarangi Winiata phrase, to penetrate Pākehā society and recruit non-Māori support, close quote, for the National Bicultural Project was a success, despite it coming to an end through exhaustion of resources. The aim to gain greater control of its affairs led to a major focus among the iwi on restoring self-determination. The fruits of all the wider battles described continue to be gathered in the present, with continuing action on protecting and restoring the rights of the people and the strengthening of iwi capacity to self-manage. The focus on language revival has led to action on many fronts related to te reo Māori. The education push led to the establishment over the same period of Te Wānanga o Raukawa. In 1980, as part of that program, the Raukawa Marae trustees agreed to the establishment of Te Wānanga o Raukawa, an institution for archives, teaching and research. That institution has been successful, Chapter 8, becoming a force in repairing the core cultural base of the iwi, repropagating the Māori language as an everyday language, developing many competent speakers among the iwi, contributing to national academic life, attracting students from all over New Zealand, and helping to frame the bicultural imperative of the nation. I'm particularly pleased that one of the first three graduates is present with us in the room today. Te Kene. The three founding iwi, Te Atiawa, Ngāti Tōrangatira, and Ngāti Raukawa, apologies to Toa for the typo there, pioneered Te Wānanga o Raukawa from its early vision as a modern institution for the purposes of archives, teaching and research into a major tertiary institution. The ancient was indeed successfully reformulated in modern form. The institution is flourishing in the new century and has become the tertiary educational headquarters for the iwi, and indeed many iwi. Despite having become a part of the statutorily recognised tertiary education sector and a recipient of Crown funding, it retains its intellectual independence and loyalty to iwi, and is now a clearly tikanga Māori centre of learning. It has indeed fostered and developed many Māori in the world of education. Chapter 9 deals with broadcasting, radio and television. Raukawa Wk Te Tonga has played a part in the modern evolution of Māori media. An experimental radio station, Te Reo o Raukawa FM, ran briefly in the 1980s and very successfully for a number of years continuously after 2004 as Te Reo FM. The radio station, the only iwi radio station to be refused funding by the Crown, was off air at the time of writing due to that denial of funding, but the other part, Raukawa station, Te Upoko Tika Radio, is on air, still broadcasting in Te Reo after 33 years. Despite repeated attacks on its status, licence and funding since 1993. Raukawa was a participant in the treaty and court cases relating to the survival of the Māori language and the provision of broadcast frequencies. These cases underpinned the establishment of a Māori television channel, Māori Television, in 2003. Claimants from one of the Raukawa hapu, Ngāti Pare Raukawa, led the generic case on the 3G radio spectrum auction on behalf of all Māori from 1998 and into the new century. The chapter contains a description of the 12 continuous years of tribunal and court cases carried and funded by Māori in order to secure a national Māori television channel from 1984 to 1996. Ngāti Raukawa as an iwi was heavily involved in this effort. It remains a remarkable fact in 2020 that despite years of successful on-air trials, 33 years of going through the channels, despite a huge talent base of broadcasters, composers, speakers and good listeners, and a rohe where most of the Māori population are now Māori speakers, Crown iwi radio policy and its Māori Broadcasting Funding Agency refuses to recognise Ngāti Raukawa ki te Tonga as an iwi deserving of a radio station. And I will clarify that majority of the population of Māori speakers, that's the statistics from the census, but it's the Otaki district, so it might not be the whole rohe. Chapter 10 covers the Māori Women's Welfare League in the rohe, which has had various branches in the region since 1951. Its members were drawn from women's welfare committees established by Māori welfare officers. Some of these branches operated for many years within particular marae and held regular meetings and coordinated activities for members. The League was mostly occupied with social problems and providing real help to whānau, but quite quickly led to a major re-entry by wahine Māori into politics. It played a major role in the second half of the 20th century over the period of urbanisation of Māori. Its branches have operated for many years within particular marae and held regular meetings and coordinated activities for members. I've got to repeat there. The League has maintained its important role in the second half of the 20th century over the period of urbanisation of Māori and addressed itself in a major way to political issues from its inception to the present. Chapter 11 is the story of the establishment of Te Runanga o Raukawa, an iwi governing council which has operated over the last 27 years as an overarching body in the social, health, treaty and economic field. The Runanga itself is a modern version of the pre-European Runanga, or iwi council regulatory body, and is flourishing in 2016 when this was written. Te Runanga o Raukawa has performed its role on behalf of Hapu, giving them the strength hoped for by founding Chief Executive Te Maharanui Jacob. Quote, beyond their abilities as Hapu, close quote, in respect of making claims, open quote, against the Crown for breaches of the Treaty of Waitangi, in researching and engaging in large-scale investment opportunities, in providing justice, education, health, social and other services, and in consulting with an extensive range of local bodies, government departments, and private enterprises. Close quote. Te Runanga o Raukawa has demonstrated commitment, professionalism and sheer capacity for hard work over 3 decades in service to its people. It has also shown steadfastness and heroism during the trials and difficulties associated with resolving long-standing grievances and with the task of unifying the iwi in order to deal with them. All of the bodies in this report, beginning with the original Rangiatea Church begun in the 1840s, are still operating under the mana of Ngāti Raukawa and its confederated allies, Ngāti Kauwhata, Ngāti Tōrangatira and Te Atiawa in 2016. The one institution that is no longer operating is its military force, maintained through hundreds of years by the iwi, until events from 1840 to 70 saw organised Raukawa military action pass into history. Raukawa military talents nonetheless made a huge contribution to the 2 world wars in the 20th century and in other international conflicts, both in the armed forces and in manpower. The sacrifices of those Raukawa and Ngāti Kauwhata people who served under the New Zealand flag. Are detailed and honoured in Taiha Kure Jury's Chapter 5 on support from within the District Māori Council Executive of efforts by New Zealanders in the wars overseas. The object of this section of the Iti Ngā Motai report was to present the efforts of Raukawa since 1820 to establish modern institutions in the religious, political, educational, health and economic spheres with the goal of advancing the well-being of the people and maintaining their identity. The report offers comment on the extent of the success of these institutions and the efforts of the iwi to maintain them as a self-sustaining system of social, political and cultural organisation. This report finds a thread audible in the words of that section of the early rangatira who welcomed traders, missionaries, governors, officials and colonists, that they were welcome to come, but on Ngāti Raukawa terms. Ngāti Raukawa showed resistance to land alienation and for several generations the importation for the blueprint for submission to empire which the British had planted elsewhere. Māori also held at arm's length Pākehā customs and the Pākehā worldview despite the acceptance of Christianity by many. As time went on, the effect of marginalisation of the language, intermarriage and belief in things Māori meant that iwi was drawn into the notion of being part of the British Empire as citizens and soldiers and latterly New Zealanders. Despite the cost of their defensive operation against land purchase, against the land court and economic marginalisation, Ngāti Raukawa, Ngāti Kaupata and Te Reureu continued to maintain marae and associated facilities for all their hapu and to establish a modernised Raukawa society operating its own institutions in accordance with tikanga Māori, Māori cultural values. The iwi resisted the idea of becoming landless and living in thrall to non-Māori overlords. The resistance was clear, both in the conduct of the iwi, in the face of the predations of the land court and the land purchase years. The general desire of the majority was to retain their language, tikanga and social structures and the mana of their rangatira, their own system of government. There was always a desire for that, particularly Māori form of hapu and iwi self-government to survive, despite the loyalty shown to the British Crown and Queen Victoria. The Treaty of Waitangi appeared to them to guarantee the preservation of this position. Despite the imposition of systems mirroring those of England, the wish within Raukawa was to become fully Christian Māori, but to resist the assimilative work of colonisation. By the end of the 19th century, the iwi of Raukawa were hunkered down in survival mode, determinedly seeing off the predictions of the demise of the race, which had become the dominant operating expectation in late 19th century settler society. Māori were invited to become citizens of the British Empire and latterly of just New Zealand. The enforced education of their tamariki in this worldview brought the iwi to a cultural threshold by 1970. From that point on, with the advent of a new wind signalling retention of the ancestral culture, Raukawa became activists in their own cause and followed a program of what Whatarangi Winiata called self-correction. In the 20th century, the Māori Renaissance led by Ngata and his fellow thinkers, some of whom were Raukawa, Ātiawa and Toa Rangatira people, and art, Ātiawa Raukawa Toa, Renaissance led by Winiata, assured the survival, hopefully, of Raukawa, Ngāti Kaupata, Te Reureu and associated rōpū as a distinct people. And we might pause there to just thank Uncle Whatarangi and Auntie Francie at home, wishing us well for that life of sacrifice. In many respects, Māori have not abandoned their own customs, plans and institutions. With the weapons provided by our newer institutions, Ngāti Raukawa is well on the road to re-establishing ourselves as distinctly Māori people. Distinctively Māori people. The nature of the confederation of three iwi, Te Ātiawa, Ngāti Raukawa, Ngāti Toa Rangatira, has changed due to the modern spirit of repatriating decision-making and influence firmly to single iwi. The old injunction of kaumātua to retain the alliance and indeed te manawa ruatanga o Ngāti Raukawa will no doubt be revisited by coming generations as these institutions continue their good work and assume new forms. He hara tēnei te mihi, ka waiho katoa e rā āhuatanga mā te tangata kei anaki. Ka tangi te ngākau i te mutunga o te tuhi tēnei pūrongo i te. Mō ngā pakeke, kua ngaro atu te tirohanga kanohi. Mō ngā hoa o tau kē. Mō ngā kaiako o whakatipuranga lua mano. Ko tai anō te kupu whakamutunga e tika ana. E whakamoe tiki o tātou mātua, o tātou kuia, o tātou kraua, Nāna I hapa I ngā mahi nui I ngā whakatupuranga kāta. Nāna hoki I tiri te māra mō a popo. E tehi, kāre kite I te taurua mano, ko e tehi kite. Moe mai koutou I te āhurutanga o te ariki. Te kai hō mai I ngā mea papai katoa ki te tangata. E te iwi, e ngā tamariki, e ngā mokopuna, hei konei, noho aki, I roto I te hauoratanga. The fourth section in the Iti Ngā Motai report by Animi Kaere and Professor Patarangi Winiata deals with the issue of tino rangatiratanga in full. Kia ora tātou.
Rongo kōrero awe ko tuki no te tuku mai nei. E hara mai ana pēa ki te tiki mai rawaru. Me whakakuri au, me whakapaia, he kai wa he rauhara keke. Te awa o taku ko iwi. Papaki rawa iho ki te tau o taku a te hepoare tonu ana kei te tarawa. Putu, koko, e ruru tōna, kai e rai. Ko te kaira tēnā, I hua I te kitatanga o te taraki I te waru. He haku kei te moana, ka pai ke te akaui. Tai rawa ki tai ki ti uri ura ki rungari rora ki te kāinga. I pai ai e te kura tau nini. Ko I ara nei e ngati Raukawa me hoki au ki manga tautari. Ki te kāinga hoki, I whakarere ana e te ngakau. Me hoki ko muri au ki te whenua, kia whakawai a mai au e te ruru. E raru tōku ki te nohanga pai.
Kia ora, we might give you a break now and take the lunch and adjournment and then come back and have questions.
Kia ora,
All right, so 40 minutes lunch break. Okay, Mr. Walker, I'm sure will not, yes, fine. You called him Mr. Phillips.
At this rate, doing up the house might take a while. But at this rate, they could pay it off a little easier. Search ANZ Home Loans.
No time for games, Agent. We've got a situation. They're hungry and can't be bothered cooking.
On it, boss. Deploying the asset.
Did anyone order pizza?
Nice work, Agent. Now move out.
I'm trying.
Oh, no. Oh. Oh!
That's $10,000 worth of hardware.
Pizza Hut. Easy, tasty, job done.
Bad doggy.
Get ready for new playlists personalized for you. With New Release Mix, Your Mix, and Discover Mix, you'll easily find music that you'll love. Play them now in the YouTube Music app.
It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
Get ready for new playlists personalized for you. With new Release Mix, Your Mix, and Discover Mix, you'll easily find music that you'll love. Play them now in the YouTube Music app.
Ngā mihi. Dr. Winiata, kia ora. So Mr. Conrad Noim, I should record, has just been joined by Dr. Bettina Winiata, and I understand the Crown has no objection. She's there to observe and to learn about how to undertake that role. And welcome, ngā mihi. So the first lawyer up to cross-examine Mr. Walker is Mr. Corniget.
Tēnā koe, Mr. Walker. Can you hear me okay?
Yes, I can. Tēnā koe.
Ko Philip Corniget toku ingoa. I represent a number of claimants, both those based in the south and those in the north, including Taihākure. First, I want to thank you very much for a very impressive and helpful report. It's clear that it took you some time to pull this together, so well done. Now, I've got a series of questions for you. Some of them, on reflection, may not have short answers. So if you think that the question doesn't have a short answer, let me know, and we can. I can perhaps put that in writing separately, but we'll see how we go.
Yeah.
So just starting, going right back. In your view, did the Church and the Crown betray any promises to Ngāti Raukawa?
The short answer is yes. The Crown certainly betrayed the promises of the treaty. And in the end, didn't prevent the alienation of the iwi estate and didn't control and properly implement settlement in a way that was beneficial to Ngāti Raukawa and all of the other parts of the treaty, which this tribunal has been hearing over the last 40 years in various land and generic claims that befell the iwi. And in terms of the Church, in general terms, yes, the Church also, it's my conclusion, did betray Ngāti Raukawa. Within our research and in our discussions with kaumātua through the years, they have singled out the courage of Octavius Hadfield in defending the Māori position throughout the first Māori Wars and in publishing extensively books and tracts which essentially led to his ostracism from Pākehā society during the course of his life. He was regarded as someone who was far too sympathetic to Māori, and he did hold that line. But at early points, and I've got coverage of this in my report and examination of some of his correspondence, he was acting actively to advise the Crown to secure its military and strategic aims. And I question that and wonder why he did do that. And one of the charitable conclusions I drew was that he was anxious that Raukawa not head off into the direction of arming and armed struggle, which is an option in the case of oppression. All Indigenous peoples have that option down to the present day. The African National Congress directly took that option, had young men being trained and operating under arms into the 1990s. So these are valid options, but he didn't want Ngāti Raukawa to suffer the depredations of war. That was my conclusion at the time in relation to Hadfield. The Church generally, and for example the large Catholic Church and the other missions there, there's interesting discussion in the Koro Tukuiho from Sean Ogden about the tribal memory and oral history relating to those tribes which joined the Catholic Church and the advice received from the Catholic clergy from France not to sell their land, as I recall Sean Ogden saying, never sell your land, you must not enter into sales. So they became active advisors in terms of the land sales, but then themselves became
suspected of being spies. They were people from a foreign country and a foreign power. The historians will do this much better than I do, but this is some of the conclusions that I reached.
Well, it was apparent by around 1846 that there were already some injustices, for example, Raukawa's arrest. And as you say, Ngāti Raukawa didn't turn to arms. Was that predominantly because of the influence of the church and the missionaries?
No, I don't think so. I think that Gray and his advisors were already influential. I think those associates of Gray had already taken the young chiefs under their wing by that point. And I think this is clear in Tamihana's writing. He was a candidate for a modernised Māori society pretty early. The change in him from, say, Kaiapo here, about 1835, that was a big battle. He was there in the South Island. And then by 1840, he and Martin de Vivi were sending for missionaries. And the change in him was pretty significant. I have to say there's a major reworking coming out of Tamihana's Life of his Father, the manuscript in preparation. The entire manuscript has now been properly translated, and I would warn the Tribunal and all other historians against all of the dreadful publications that have come out from that one very long manuscript over the years, and none of them are accurate. They're all riddled with error. I'm talking about dozens on each page. But it's been redone by Ross Kalman in a book I understand will be published this year by Auckland University Press, fully annotated, of the entire period. And it gives the actual person, you can hear his voice, talking about his reaction during this period and where he was going and his thoughts. So they'd been, a lot of them, to Sydney. They'd seen the model, how it would work. They'd get a small town, they'd develop a port, they'd have a decent mission station with a good school, and they'd begin the trading, and trading would get underway with all of those goods, desirable goods, the iPads of their day. They were into it. They were literate quickly, and they would get a dairy. They'd have all of the things that came with a bit of dairy farming and all those other things, and they learnt those skills too. They learnt how to read plans and so on. And then, on to Raukawa's capture, the tables were suddenly turned on them. Their father was imprisoned, and Gray had a plan, and he essentially, I believe, forced the sale of the Wellington blocks, which the young chiefs signed. Tamihana, Martin de Vivi, and Rawiri Puaha of Ngāti Toa.
How did that loss of land and economic base affect the hapu of Ngāti Raukawa?
It was a true devastation. I mean, it didn't... the cycle of purchases, the historians will give you all of the exact dates. There was the Turakina purchase, the 1848 purchase, and then the later big sale, I think 1868, the Manawatu. Everything went with those two huge blocks and two huge amounts of acreage of the hapu living along those rivers, and settlement was opened up. And I think, from my reading of the record and the letters that I've translated from that period, is that there was a fairly rapid onset of indebtedness and poverty from that point. Māori, if you look at someone like Keith Sinclair says, Māori got very quickly into the inevitable trap of living on the capital, selling land. They had income, they were making money. There was something like £30,000 in those earlier years in a fairly short period, and then it rapidly began to dwindle, the income to the rangatira and hapu from having a capital base. And then the slide from there into poverty was very quick. And the poverty was absolutely dire in my reading of it. by the late 1870s. And it's interesting to me to note that it's the parents of our kaumātua who I've mentioned here today, some of them born 1920, 1930, their parents born in 1880 were the ones that decided to rapidly modernise, and they decided their children shouldn't speak Māori in their home. And I believe that's a direct experience of the combination of poverty and racism operating in settler society. How could Māori get into employment? The discrimination continued and continues today. Pākehā people have the jobs, award the jobs. How do Māori get employment? And that extends through many other areas, right to accommodation. The debate is still ongoing. If you watch Te Karere and Te Kaya, but that has been the reality. And I've heard our kaumātua Te Hākure say in his estimation that the amount of land was so significant, he believes that the loss of land in the Rohe was the largest of any iwi group in the country. And he may explain, clarify that statement for you when he speaks, in terms of a relationship to the population.
Did the forced land sales create a division within Ngāti Raukawa?
Trauma and division. And I believe that they changed everything in terms of people's relationship to whakapapa and whanangatanga, and their feelings about their place in the world. It was an experience, if you like, of subjugation to an imperial force that had set its sights on the rich prize, which was the rich lands of Ngāti Raukawa. And that trauma and the division, I have to say, I think, actually, like a lot of trauma, got buried. I've had experience with our own aunties and our own families who didn't really want to talk about it too much because there were very bruising encounters with it. I think it led to the iwi not teaching its children the truth about those things. I think I'm a product of that. There were things I didn't find out until I was asked to do this paper about the history of our own iwi. And so I would say, as a teacher, because that's really been my role, I've been teaching essentially the sanitised, approved by kaumātua curriculum of Ngāti Raukawa to our young people. For a lot of our lifetime we've done that. We've taught a sanitised version of our own history, highly sanitised. Because if you go far back, how do you cope with sales? How do you cope with where your ancestors were sitting? How do you cope with what went down? In my own family, there was a huge case over a very rich piece of Raukawa land where the siblings were all split, my great-grandmother and others. And that went to the Supreme Court of New Zealand. 8 siblings. And the non-sellers lost. I mean, my great-grandmother could have been a seller. Turned out she was a non-seller. I don't blame anybody. But that is how it was shaking down, and family by family by... I was never told about that. I think I found out about that when Papers Past was digitised, Dr. Phillips. The detail, and this is common. My own grandmother used to say to me over and over, the Māori people have never had a fair go. Yeah. But didn't go back too far to pick these things up because of the level of pain and the mamae and the guilt that a lot of people feel about those times.
So when do you say that the loss of language and culture began among Ngāti Raukawa?
Language and culture, I think the language was alive and throbbing through the 60s and 70s. There were 2 generations interacting with each other of adults who were both native speakers. But then you began to get a generation whose who were born as native speakers in 1880. This isn't scientific, but for my own, I've recorded a lot of the kaumātua in the southern North Island. I've recorded a lot of them, and in the Wairarapa. And my sense of how it happened in proximity to Pōneke, I think a lot of the switch was already done by the time of the First World War. The First World War, I think a lot of the kaumātua, a lot of the children who were being born at that time were becoming English speakers, from what I found out from them. And after that time, many of them were Māori speakers in later life, but they actually taught themselves. So this language learning thing is actually not a new thing. They decided to be Māori speakers, and a lot of them did it through the Bible. They'd read the Bible alone to themselves in the bath, on the bedroom at night. They had all sorts of strategies. And these are distinguished kaumātua. Uncle Pat Ray, he won't mind me saying this, but he was born with a stutter and told the story of how he used to go under the mill at Waipa and recite over and over and over all of these whakatauki and his the tauparapara he was able to pick up and learn, and became a nationally known orator, but by dint of effort. So it really requires this huge passion on behalf of people to recover it. And that generation, up to the First World War, were the ones I think were the ones who, I'm speaking perhaps now of what my knowledge of the southern North Island is, and I don't want to speak for Ngāti Toa, I can't do that. But Ngāti Raukawa, I think it's quite clear that the experience of exclusion and marginalisation, and there's some very good sections from Meriana Selby in the Wānanga, in the Whakatipuranga report in Māori, which are translated there in chapter 7, where she gives detail about her grandmother's views, Atarete, and her decisions explicitly, the reason why they were made. The discourses, the Māori people were disappearing. The children had no future. There will be no Māori left. They're at desperation, so they'll make an explicit decision. They'll back up the educational effort in the kura with English at home. And actually, it's interesting, the exact reverse is going on in my family these days with children in kura and kohanga reo. We've got younger parents, my children with mokopuna, doing the exact reverse, and one of them said to me last night, you have to have it operating like this. You have to have the kura and the kohanga, but you must have a parent speaking at home. Otherwise it's too hard to get the mokopuna speaking, actually operating as a little Māori speaker, and that's what the goal is. That's what the goal is. So back then, I assume it was very much like the reverse of that. And then there's some revealing interviews which I'd done during the Rangiatea Oral History Project with Uncle Tahi Wikakik. And his parents were born about the same time, and Whatarangi himself talked about his parents. Looked like they'd made a similar decision, although Whatarangi is not exactly explicit on it, but a similar decision. We were raised without the language. And Whatarangi described his pain because he wanted to be able to talk to Paora Temwera as a young person. He wanted to be able to talk to him because he gravitated to Paora, the canon at Rangiatea. He's a big influence. And he offered that regret. And Tahiwi offered it as a regret. His father had a rule that when elders came to his house in the 20s from Otaki, they were not allowed to speak English, to speak Māori. He would declare to his own cousins, he kāinga kōrero Pākehā tēnei, we've got to speak only English, because the children were there. And at a certain point, his frustration boiled over and he had a huge argument with his own father. You can see it. But the loss of a language is so huge. The loss of a language is such a big one in terms of what should be the reality for Māori with something so beautiful just right in front of them. Their bicultural, their bilingual inheritance, and the ability, and it's if you're a natural speaker, and it should be effortless for them. They should be participating, and not just for the hohonu, all sorts of other things. They should be able to effortlessly and freely have fun and laugh and make friendships without even thinking about it in te reo. And that's a major, major loss. There's a lot of discussion about whether the other Māori leadership encouraged it as well. It's said that Sir Apirananda, at one point of his life, was advocating the school's policy, but it's said also that he changed his mind very vigorously I'm sure Dr. Suter might have some comment on that. Yeah, tika, correct.
Why did many of...
I'm sorry, Mr. Corniget, it's 15 minutes.
Just one final question, if I may,
Yes,
Your Honour. I'll put
thank
my
you,
rest of my
quickly.
questions aside. Why did many of the institutions described in your part of the report operate from a southern base rather than a northern base, if we're thinking about the inquiry district?
I think the creation of the trustees, the Raukawa Marae trustees, by law associated with Raukawa Marae and Otaki made it an automatic Otaki one. And the later institutions in my report did start off associated with Raukawa Marae as well and the Raukawa trustees. That's Whakatupu Rangarua Mano. And then Te Wānanga built in Otaki. It converted the old native school buildings that's described in the report. And so there were three kind of in Otaki. The Māori Council, the District Māori Council, the push and the impetus for that were in the north. It seems to me from my reading, and certainly from Tai Hakure's chapter, the service and his hapu and hapu in the northern area, the Raukawa District Māori Council was very much associated with that and interacting with Ngāti Apa, Rangitane, and all of those other iwi in the rohe. So they were very active in that area, and it seemed to me the League too, the most activity, and well, not the most, but certainly a great deal of the activity in the League had come out of Te Reo, Foxton, Parewahawaha Bulls, and that area. So there were major institutions that were operating in the north. And then the other thing is that Whakatupu Rangaruamano and others attracted supporters and participants from every iwi and all marae. And I think that in many ways the sense is that the treasure is unity and that access is for all. And in some ways too, the Confederation itself could be seen as an institution, and that's all three iwi, and extends a long way from Whitireia to Miria Te Kakala to Rangataua. So a long, long way up the coast, taking in everybody.
Well, thank you very much, Your Honour. If I can put my remaining questions in writing, and also if I may be given leave to withdraw for the rest of the afternoon.
Yes, thank you. All right,
Thank you, Your Honour.
Mr. Beaumont. Mr. Beaumont's not online. Mr. Lambert.
Tēnā koe, Mam. Tēnā koe, Matua.
Nā koe.
Ka pai. Ko Nita Lambert taku ingoa. E uri au o ngai tūhoi me Ngāti Ruapani, nō reira tēnei te mihi ki a koe.
Kia ora nō koe.
Ai, tēnā koe. I represent claimants John Rewati and Tamahau Rowe for the Y1260 claim on behalf of Ngāti Waiwai and the Y1619 claim John Rewati for Ngāti Parewahawaha. Nō reira, tēnei te mihi, e patu ngā kōrero, ngā pātai, nō reira. My question is in regard to the individualisation of title and its effect on hapu leadership structures. In particular, I just wanted to ask the question if within your research you were able to give much consideration to the effects of the fragmentation of land and the effects of that on hapu leadership structures within Ngāti Raukawa, within the iwi, within the hapu.
I didn't do a chapter on the operation of the land court, and to be honest, I didn't research the question of individualisation of title. There are a number of analyses of that, and some people have said in recent times that it's possibly not a bad thing because it's prevented the alienation of blocks when you've got 2,000 owners.
Sure.
But at the same time, it's something that I didn't study and I can't give you a further answer on, unfortunately.
Sure. I mean, I wonder if I could reframe it just to see if I can tease it out. If not, then that's fine. So I guess the premise is that the diminishment of the land that used to be collectively owned, under traditional tikanga, is then parceled up into smaller fragments. So essentially, what you have those once well-respected rangatira that had the autonomy over large areas of land. Now, when they start to be fragmented, then the rights, the ownership rights, become individualized to smaller groups. So you get all these smaller pockets.
Yep.
So it essentially diminishes the rangatiratanga.
Yep. Yes.
Would you agree with that?
Mr. Lambert,
it's a profound
sorry,
question.
Mr. Walker, I think you've already answered the question. You haven't
That's
studied
fine,
it.
Mum.
Yes, it's not in his report unless you can refer to a page reference.
No, that's fine, Mum. I'm happy to leave it there. Thank you. Sorry, no more questions, Mum. Nō reira, tēnei te mihi ki a koe.
Kia ora, Newton.
Ame.
Kia ora.
And thank you, Mr. Lambert, for announcing who you're acting for. And as I've asked other council where I'm not sure, because the situation was different during the whole time we went through the kōrero tuku iho process, is your client an individual of Parewahoa, and are they representing Parewahoa, or are they claimants who have filed a claim that is one part of the iwi?
As far as I know, the Y1260 claim is on behalf of himself as part of Ngāti Waiwai, and the Y1619 claim is as a representative.
As a representative, thank you. Mr. Watson?
O tēnā koe e te rangatira. Ko tēnei te mihi atu kia koe. Nau e nei mahi rangahau I puta. Ngau ngā wawata, ngā mamai hoki o ngā mātua tupuna I kohi. Kei te whakaro hoki ki tō tino hoa, ko huirangi, ko whetūrangitia, kia rātou hoki. Rātou kia rātou. Nō reira, pirapi tēnā koe. I'm really grateful for your mahi. I act for claimants who affiliate to Hapu and the Otaki Rohe. And on their behalf, we send our acknowledgements to you and the others involved in this important research. Just through you, Mr. Walker, I want to just advise Her Honour that a series of questions were put to Mr. Walker in writing. Yesterday, answers to those questions came through. It appears that through no fault of counsel assisting Mr. Walker, there was a miscommunication as to the filing of those questions on the record. I've got no objection myself to the late filing. I've taken instructions on those answers overnight, and I understand that they have been filed by Mr. Rogers with the tribunal. Having read those responses, I'm happy just to leave my questions there, Ma'am, and want to thank Mr. Walker for his research. Nō reira, tēnā koe, tēnā koutou.
Yes, thank you. We were given copies of the answers of Mr. Walker to questions of clarification at lunchtime today. What's the document number? 3.2.729 is the document reference number now, and I just want to make sure that Ms. Cole has a copy.
No, sorry, this should go on the H series. It's in another attachment to H1. It shouldn't be on the 3.2 series.
Well, that's true. It's evidence.
I agree with
Okay,
that,
so
Dr.
we
Grant.
need to give it another document number, but in the meantime, while that's happening, will you give me your, can
So-
you indicate whether you've had a copy of these?
So I received an electronic copy of it earlier today, but I haven't had a chance to have a read through it. I wasn't provided with a printed copy of it, so I haven't had a chance to read through it. And
Well,
given that,
council should be supplying
I
copies
know
when
that,
they...
I know that, Mum,
All right,
but they didn't.
okay.
Thank you.
Ma'am, just to put on the record that we've handed printed copies up to Tribunal staff and have circulated the electronic copy to all.
Thank you.
Given they were questions in writing from Mr Watson, however, of course, we have no objection to the answers being given in writing. And it's just that I haven't had a chance to read them, so I don't know whether they're going to affect any of the questions that I've got lined up. So
That's fine. Why don't you ask all the questions you've got lined up, and then that'll probably take us to the afternoon adjournment anyway.
Yes, thank you, Mum. Yeah, I was just going to say that the time that we had estimated for asking of questions and answers might have been slightly short, having regard to the fullness of your answers, and I am more than grateful for the fullness of your answers, so I'd rather not truncate your responses, but I would like to try and get through the questions that I've got. So, tēnā koe, Mr Walker, it is nice to see you again.
Tēnā koe, Ms. Cole.
Just noting that Mr Walker was the interpreter for this inquiry when I first started 5 years ago on this inquiry, so it's nice to see you again.
Nā reira kia tika tō kororo Māori mai.
I'm not sure what you said then, but I'm sure I'll find out later. Mr Walker, actually, I've dealt with the extension issue. I just wanted to say, as a girl from Otaki, that I have no doubt that your report, despite your comment earlier when you first started about having no qualifications whatsoever, that really underrates the quality of this. And I believe, personally, and I think I can say this on behalf of the Crown, that your report is likely to be revered for many decades to come in terms of the content that it has. I'm sure it's going to be seen as an authoritative source of information for many people of Ngāti Raukawa, and particularly, and also for people who are not of Ngāti Raukawa, who I hope will one day get the opportunity to read this information that you've provided, because it truly is very informative and, in my opinion, not that it means anything to the Tribunal, very authoritative. So, on behalf of the Crown, I do wish to thank you for the very hard mahi you've obviously put into this, and the quality of this report, which is so easy to read, which makes it a pleasure to read and so easy to understand. So thank you.
Kia ora anō. That's the nicest thing anyone from the Crown has ever said to me.
And I didn't even pay you. Mr Walker, I just want to start, I just want to work through it, through the pages. So if I can turn first to page 320 of the report. And in the first paragraph there, you mention that, or you say that the most recent institutions, whakatupuranga rua mano, te wānanga o Raukawa and te runanga o Raukawa, can best be described as part of a self-correction to recalibrate the iwi, to recover mana, repropagate identity, educate the individual, and ensure an economic capacity. And my question is, do you think that that has been achieved?
Ms. Gold, I've got a different page number, I think, in this reports I brought. These are the ones that were sent to me.
So the document I have in front of me is H1. I didn't know that there'd been...
These were mailed to me, and...
okay, it's the very first... So if you go to the front page of part 3...
Yes.
And then there's an acknowledgements page.
Yes.
Can you tell me what number you've got at the bottom of your acknowledgements page?
At the bottom of the acknowledgements, I've got page 326.
Right, so I'm going to try and add 9 to all of my page number references.
Thank you, Ms. Cole.
So hopefully then, if you go to page 329,
yep.
Yeah, 329.
Adding 9 or 3?
329.
Yeah.
Sorry, since I have 318 at the bottom of the acknowledgements, can you also give us...
I've got 317.
Oh, sorry, I'm looking at the second page of it. Could you also give us the original number plus the calculated addition for Mr. Walker?
Certainly.
My maths isn't good enough to work it out without that.
And perhaps I'll also mention the first few words on each page. So this would have been page 320 of the copy that I've got, which would now be page 329, I think, of Mr. Walker's copy. And the very first word is Pakeha, hyphen in numbers in the Cook Strait area, the top of that page. This is not going to work out very well.
I found it. Yes, thank you.
Great. So at the bottom of that first paragraph then, it says the most recent institutions, the 3 institutions, can best be described as part of a self-correction. Can you see that?
Yes.
Right.
Yes.
So my question was, in terms of the self-correction, recalibration of the iwi, recover mana, repropagate identity, educate the individual and ensure an economic capacity, would you say that those aspirations have been achieved?
They've been begun.
Begun?
I would say only that they've been begun.
And work in progress?
A work in progress because, for the life of most of those institutions, they were run on voluntary labour, and they were running in the old buildings of the iwi. The Wānanga building had possums living in it the first 10 years of its life.
Well, I can actually give a personal account of that particular building. My father, who was a builder in Otaki for all those years, his father was Huia Cole. Yeah. I can remember taking him lunch when he was working on the foundations and re-establishing or redoing the foundations of that building. So possums, yes, I remember them.
Yeah, that's interesting. But the point that I'm making is that the effort was huge, but the recalibration is enormous. It's trying to do 4 generations of work in 1 generation. And I think it caused its own huge weight and possibly its own stress fractures, I think. That's my hunch now. But it was worth doing. A 180-degree U-turn was worth doing. But the institutions that they also sought to set up, radio, for example, and television, operated on shoestrings. The television battle didn't happen for a long time. Those court cases from 84 to 99, the 12 years, were only court cases. It was a dream, and the Crown didn't accept it. The Crown had to be dragged along, and then dragged along. The funding and capital establishment of Wānanga, the Crown had to be dragged through the tribunal. And alongside all of these things, which, in a society that was really wanting to do stuff quickly, you would establish royal commissions that the Crown would fund. Māori funded all these inquiries for decades. And this kind of continues today. We've got live entries on the broadcasting front in front of the tribunal. So in terms of the re-establishment of the iwi, and in terms also of the arrival at a new economic order, if the treaty had been honoured, I particularly like that chapter by Paul Teem in his book on the Waitangi Tribunal, that opening chapter. He describes what New Zealand would look like if the treaty had been honoured. Māori would own the New Zealand transport system. They would own the country's ports. They would own its airports. They would certainly be still the major holders of the horticultural system because the best land wouldn't have gone, and so on. And if you think of that in terms of the breach of the treaty, the recalibration, we're only, mucked about with it. And that is what the final chapter from Anime Kaere, which I hope is going to be presented to you in full, is about. And that's why it is the final chapter of the Iti Ngā Motai.
Well, we'll look forward to the presentation of that. It segues, some of the answer that you gave there segues into my second question, and that was, it's on page, I think your page 332, and there's a photo of the 3rd birthday of Te Upoko e Te Ika. So that was page 323, Dr. Grant. You make a comment on that page about the radio station It was the only iwi station to be refused funding by the Crown. You may not need to even look at the particular page. My question was, do you have a recollection as to why there was a refusal of funding?
This is an interesting thing. You can get the big tribunal decisions. You can have the language declared a taonga, and you can have the Privy Council in London say that the Crown must show measurable progress in both radio and television. They were very interested in it, and they awarded essentially Māori television. It was awarded by an offshore court, highest court in the Commonwealth. Gave us Māori television. But then you come down to the little details, and, my dear friend Huirangi and us, along with some of our kaumātua in Raukawa, were part of a movement in the 80s, possibly earlier. Actually, it was alive always. I'm quite wrong to say it emerged. Of deciding to go, and this is Whatarangi's phrase, in terms of strategy, onto the front foot. And this is a big departure for senior Māori rangatira in the 20th century to take on the Crown again. The Empire Project, the colonisation project, saw the attempt to dovetail in and to work and to get to a certain point. By then, they were prepared to imagine a future whereby other kinds of triggers and mechanisms could be used, and in some cases used to thwart the wishes directly of the Crown. And they were prepared to do it. Well, in terms of radio, there were casualties. I believe that there were casualties. Treasury decided to introduce a cap of 23 iwi stations and said that cap is a good number, that's enough. There are only 23 iwi that will have a radio station in 1993. The cap remains. The cap remains. So it has been unmovable. And it's not legislated at all. We better move on to the next question. I could talk to you for too long on this.
I think you have answered it by talking about that cap. So the refusal for funding effectively came because there were too many, and too many Māori stations, and they were competing with each other, and the Crown wasn't budging on the number of stations it was going to fund. Is that what you're saying?
Yeah, well, it's nonsense. I mean,
I'm not disagreeing with that.
Indigenous societies like the Cree in James Bay in Canada have 14 radio stations. They only need to be as big as your laptop, and a small transmitter that you could carry around in your day pack. And they could broadcast to 14,000 people in Te Whanganui-Aotearoa. We've got a little transmitter on our building over here we put up a couple of months ago, broadcasting 8 kilometres that way and 8 kilometres that way. And it's small, tiny. The thing about the technology, it's like the Viet Cong. It's small, cheap and portable, and it could have done immeasurable good for the language during those critical times. And Raukawa were ready to go. I think at one point in the 80s when I was a music producer, Radio New Zealand, I counted, if you include couples that sang together, like Francine Whatarangi, and recorded LPs, there were 300 in Arohe. We were as good as Ngāti Pro. And we should have had a blimmin' radio station. And we didn't get one.
Thank you.
We better move on.
My page 330, Dr. Grant, probably your page 339, Mr. Walker. The heading is The Place of Religion and Mythological Teaching in Institutional Underpinnings. And you talk at section 1.3 about Māori ideas of creation and the gods. And you note that in 1856 in Otaki, Hukiki te Aka Karamu, I'm sorry, I'm probably completely butchered that name.
Te Hukaramu. Yeah.
Thank you. Dictated creation, whakapapa and stories to Donald MacLean.
Yes.
My question was, do we have any knowledge as to why the senior rangatira passed this knowledge on to Donald MacLean of the Crown? What I'm seeking to explore, I suppose, was there an element of trust there? And if so, was that trust abused by the Crown?
On the reason why, MacLean was a good writer. He became a fantastic transcriber. I actually found those diaries in the Turnbull when I worked there. I found these sections in the MacLean papers and recognised they were from Otaki. And with the help of Sharon Dell, the librarian at the time. And Maclean is a highly complex person. If you're interested in your Scotsmen, he was a Gaelic speaker, and he warmed to Māori society and worldview. And as a young fellow, he was only young, he was the police constable up in New Plymouth, but he got close to the rangatira. He got close to Te Reo and others, and sat with them. And, you know, not being a native speaker of English, he was also very, you know, he didn't do good for us on the land. And that will all come out in these hearings. And I don't want to go into that area, but in terms of your question, by the time he was operating in 56 with his little notebooks, he would have been speaking Māori pretty blimmin' well as his third language, possibly more. And he was interested to get them moving on those traditions, and he would probably be comparing them. They all did it. Richard Taylor did it. All of the ones who were natural linguists. In the Hawke's Bay and Wairarapa sales, it's clear to me that he was able to transcribe whai kōrero on the marae verbatim. He was that quick. He's got all of Te Hapuku's whai kōrero down verbatim from the day they were delivered.
Just the last component of the question that I put was whether you have found any evidence of misuse of the kōrero or the whakapapa that was entrusted to Donald Maclean.
No, I didn't. He didn't seem to breach the trust. He was called back in, as will come clear in this inquiry, by Raukawa Wk. Through the period of the difficulties in the 60s and 70s, he became the one that they insisted on calling back. He was in regular. I've translated lots of his telegrams for this inquiry. And so he was one who was believed to have a closer affinity with the wishes of iwi and hapu, not always, because ultimately his heart was in the colonisation project. I think that's the conclusion that others have drawn, and that's the conclusion I've drawn as well.
Thank you. If I can move on to my page 363, so that would be your page 372, I hope. The lines at the top starts to Winiata, comma, if you can find that page.
What will be, sorry?
So yours should be 372.
And what's the nearest paragraph number you can see, please?
It's just before 2.5.
Thank you. Yes, found it.
Right, so the paragraph immediately before 2.5. You make a reference to kōwhata. In evidence, Waitangi Tribunal 2014, Lawton recorded the house Akapita lived at kōwhata. We heard some evidence earlier this week about, or a submission from council, regarding kaiwi pā being called kōwhata. I just wanted to query with you, when you say at kōwhata, do you mean the kōwhata also known as kaiwi pā, or do you mean the kōwhata up north, in the central North Island?
No, I mean kōwhata here, not the central North Island, I mean the kōwhata down here, and I'm just wondering because I haven't attributed that quote, which I should have. That might be, is that?
Would we
That's come, I think, from Tata Lawton during the kōrero process, from a transcript. I think. Tigini? Looks like Tata's commentary that he gave on the bus that day when we went round.
So that would relate to the
kōwhata
area,
here, yeah.
Which is that we're talking about, the
Yes.
Kaiwi Pā area?
Yes, I think.
Thank you, thank you. Okay, great.
Can I just ask that you confirm that later with the hapu, recheck
Yes,
that, please?
I was thinking that when
Yeah,
you were talking,
thank
actually,
you.
we can take that up with the tangata whenua.
Yep.
2.9 is the section. It's about the fire at Rangiatia. So it's my page 376, your page 385.
Yep.
My question was whether or not the Crown contributed in any way to the rebuild or funding for the rebuild. If you have any knowledge of that.
I can't give you an accurate description of that. It would be good if you could ask the Otaki Hapu and the rebuilders, the big team on
I
that.
thought I might try and seek some information from the Ministry of...
My memories of that would be who I attended at the time, and it's now hazy in my mind.
Thank you very much. At the end of the very last, in your summary of Chapter 2, so your page 390 probably?
Yep.
2.13. You say that until well into the 20th century, most whānau believed profoundly in the existence of the Christian God of the Bible and practiced their religion assiduously. And I couldn't help but note that you'd written that in the past tense. I was, when you refer to well into the 20th century, I just wondered, has it changed over the past century or so? And if so, in what ways?
I think I mentioned in the report that the change to a healthier relationship with your own language, becoming a Māori speaker changes things. The children start to address directly Papa Tuanuku, and Mediana Selby's got a wonderful story of her child there. And my own mokopuna are doing this all the time. They speak in Māori ways, taught by their kohanga teachers, and then they become attracted in their primeval parents, Rangi and Papa Tuanuku. Rangi kaheke said, ko tahi anō te tipu no te takata Māori. Ko rangi nui e tūnei, ko Papa Tuanuku e takotake nei. That's the beginning. And so the Māori heart sort of can't shut that out. That's the thing. And perhaps to answer your question, as a teacher at the wānanga, I noticed in the 90s, when I was back teaching full-time at the wānanga, they reached a certain point at our hui, you had prayer. In the old days, there was only the bell. You get taught how to ring the bell properly. Ding, da, ding. You don't just ring it once, you've got to walk around the whole marae. Then out on the street, to get all those Ngāti Raukawas to come to kariki. And that was the practice. By the mid-90s, by my count at one time, by my guess, about 50% I assessed of the rangatahi enrolling at the wānanga were not necessarily Christian. They were indicating their wish to be part of the ancestral beliefs of their ancestors, and they were asking for karakia along those lines, and they were wondering how it can all fit in. They were cross with colonisation, rightly, and then we had to develop protocols for how to handle everybody's wishes. And the only way to do it is you have to become pluralists. You have to become pluralists in the modern world. So everybody gets a fair shot and nobody gets criticised or told they're on the wrong track. That's pluralism. So everybody bumps along. And to its great credit, the wānanga, which began at the mission church and with a very heavy church influence, and the whakapono was a major part of the wānanga Raukawa and the elders that built it. But to its huge credit, and I think it had to do this, it has become a major part of the restoration of the traditional religion, which I say in my report, I believe personally, it's a personal belief, is actually one of the great religions of the world, the prior Māori religion. It used to be terrible to say that in the 19th century you'd get into trouble with the priests and everything. And nowadays the Pope is writing encyclicals about it. It's common sense. It used to, the difficult idea used to be one nation, two languages, and that's become accepted. And now the idea of multiple beliefs is accepted. Or as Ruka Broughton Senior said to Sir Kingi Ihaka, when questioned, I've got my own Old Testament.
Ka pai. Can I ask you just briefly about the Raukawa Marae Trustees, created under the 1936 Māori Purposes Act?
Yes.
So this is on page 405 of the version I've got, which would be 414 of your version. It's section 4.4. And you noted that under the 1936 Act, the trust was exempt from rating.
Yes.
And subject in certain ways to the intervention of the Māori Land Court. I wondered if you had any information as to how it came to be that the trust was exempted from rating. There's nothing that's evident from the legislation itself. I wondered whether you had any knowledge as to how that came about.
No, I don't, unfortunately.
No, that's okay.
That's a detail I didn't examine.
It could be something that Sir Taihakuru knows, actually, so it may be something that I could take up with him. I was wondering whether it might have been, for example, because of, or as a consequence of lobbying by the Raukawa trustees?
Yeah.
Something like
the
that.
The Hapu of Otaki will know,
Yes.
and researchers like Rupeni Waka will know.
Thank you,
Yeah.
thank you. Section 4.6 is the new direction for the trustees. And my page 407, so your page 416, I think. It starts with the page starts with a quote about a carry cot.
Oh, yes.
But the question this paragraph I'm looking at is the second to bottom, talking about a hui in 1978, where the trustees adopted 9 proposals that had been discussed with the government,
Yes.
including amending the Māori Reserve Land Act, seeking financial assistance to help marae cope with the cost of educational visits, etc. My question was, the government was supportive. Was the government supportive of the activities of the trustees? So the proposals that were being put were being positively supported by the government?
In 1978, again, that's just a little bit of outside
Okay.
what I researched.
Okay.
That particular way. In general terms, my comment would be that almost all of the large aspirations of Whakatupuranga Ruamano and the trustees at that time, they were all a struggle. They were all a significant struggle. My memory of it.
Just over the page, so there's the next page, it's got a photo of 2 children on it, tamariki. And then page 409 on mine, it starts language only at the top of the heading. So this is it's still on the same section, talking about the new direction for the trustees. There's a reference toward the road towards conducting iwi activity in the Māori language being a difficult one for many, which I understood to be the tangata whenua, essentially. My question really was...
Sorry, Ms. Cole, can you give me the paragraph number again?
We're still under the section of 4.6.
Yes.
And it's 3 pages in from that.
Yes.
So there's no paragraph number as such. It should be your page 416. No,
Yep.
418.
Yeah.
There's a picture of Raukawa Wk at Otaki Racecourse on the page.
All right.
There's a picture of Whatarangi Winia.
I thought it was, yes.
Yes.
That looks like the one that I remember, Whatarangi Winia, Mr. Winiata, that I remember.
I'm going to swap versions. Thanks, Donna. So 5.4 point.
I might ask Conrad to translate that title, given that the title of the picture, just for the record.
Kia ora, Mum. So you should be looking at the top of page 418.
Yep.
And there's a photo of Mātua Whatarangi with his
Yes.
arms in the air, obviously.
Yes.
So there's at the top of the page, the road towards conducting iwi activity in the Māori language was a difficult one for many. My question was if you could elucidate on or expand upon why that was such a difficult road.
Simply because these were senior adults, but they were not able to speak Māori. They would be frank about that.
Okay.
And they were asked to go and participate in classes with people of all generations, and the production of everything is difficult. If you've not had language before, it's not a 1-day thing, a 2-day thing, it's not a 3-year thing. It probably takes 10 years of assiduous effort by an adult to achieve modest competence in any language. It's a decade. So they were there being asked to participate in immersion hui and others. And there's also the fact that they didn't feel that they could begin. Yeah. It was common experience for those of us that were learning to be sitting among our very senior elders, a table full at the wharekai, who would be very, very frank about it, and they would just say, we haven't got any Māori parapi, and then you feel te awa, and they would say, but look at you young ones, learning the language, but imagine the position that they're in, seniority, and then everyone's suddenly getting on this thing with the language. Iwi Kate pointed out this particular problem, about those hearings have thrown it into sharp relief. What are the place of those who haven't got the language? And then Kiri Puwai's description of the rights of non-Māori speakers. She came away from one hui and challenged everybody who was trying to make people in the kitchen speak Māori, the best cooks in Otaki, and her challenge was, so what are you saying? if you can't speak Māori, you're out. That's not going to go.
You'd agree that there's been a significant change in the last 4 decades, in terms of the number of, we see it when we're in these hearings, for example, the incredibly impressive number of people who can clearly speak and understand what is being said.
Yeah. I think that's borne out in the census I mentioned earlier. Are you aware of those figures? That Otaki now, the majority of adults who are Māori are also Māori speakers.
Mm.
So Otaki could rightly claim now to be a Māori speaking town. And among children, I'm sure it's higher for Māori children.
You make reference, I think, in your paper about people speaking Māori to each other in the supermarket.
Yes.
For example, yes.
Yes.
Just conscious of time, I've got a couple of questions from Chapter 5. I might just put them, I'll just say them, and if you know the answers, that's fine, but otherwise I can park them for when Sir Eddie is here. The first one was with respect to the Raukawa District Māori Council and how active it currently still is. And will it remain active? My question was going to be, will it remain active once there has been a treaty settlement? And there's that process that's gone through for treaty settlement purposes of mandated settlement organisations or post-settlement governance entities.
Yep, that's I'm sure it is active. The Māori Council has been through a major, quite revolutionary revitalisation in the last 6-8 years with elections, re-establishing its kaupapa nationally, and it's really doing its business well. But I'm going to get into a lot of trouble because there's 10 institutions in here. If I try and answer sharp-end questions on their aspirations, on all of these, I can feel myself sinking into trouble.
No, that's absolutely fine. And the second question that I had in relation to the Raukawa District Māori Council was on page 415, so your page 424, there's a reference to the King's decision to adopt wardens, and it talks about the district councils have developed processes like community resolution, restorative justice, effectively training wardens, which is driven by kaupapa other than policing, or by the police. And my question was whether or not you're aware of whether steps have been taken to actually continue to develop this, and if it's something that the Crown can assist with in terms of that sort of development. I reflect, for example, when I first started practice and I was in the Bay of Plenty, and at the Whakatane District Court, the Māori wardens would be there every court day, and nobody messed with those ladies. They sorted things out, and they got things working very well. And I wonder whether that's still the sort of thing, with the support of the police, and if that's the sort of thing that you're talking about here, and whether or not it's something that can continue to be developed.
I would leave that one for Te Hakure, but express my wholehearted support for the wardens.
Okay, my next question is in Chapter 7.
Yep.
My page 462, so your page 471. This is under the heading, the Education Mission, which is section 7.5. So those 3 missions that you gave us information about were fascinating. With respect to the Education Mission, you say on page 462, 471, despite the fact that by the year first of all, you have a table which sets out the professions and the present and future, who'd become accountants, who'd gone into law, who'd gone into medicine, etc. And you say, despite the fact that by the year 2000, the end of whakatupuranga rua mano, not all of these targets were met. And then you say, in some cases, falling short by a long way. But there is little doubt that the wānanga and the generation 2000 had produced results. I just wondered whether there was understanding as to why the goals hadn't been met. Was it, for example, lack of resourcing or lack of interest by people who might have been otherwise involved, or?
Yeah, I know that I was sure of that statement when I made it, but I just can't quite track my thinking on the numbers of why falling short was a long way. I might have need to have that planning document
Perhaps
beside me to see.
So if you do have an answer that you can put into writing, then that would be fun. Just for an understanding, really, as to the goals were set And of course, we all set goals that perhaps we might not reach, but we certainly aspire to. But these goals, as you've pointed out, were quite significantly not met. And I just wondered if there might be an explanation as to why that was.
Yeah. 10 by 2000 in architecture, 10 in engineering well, that was for the whole Confederation, I think, eh? It's the whole of the mission, the whole of the Confederation of 3. So, yeah, other experts, I think, should have a look at that and review, if we do a full review of this again in the future and just see. Because there are many, many people, there are people studying, for example, the American universities in Ngāti Toa, who do qualify, and my conclusion may be wrong. What have we got? Professional music 5 by 1985. Yeah. Well, that's not necessarily New Zealand Symphony Orchestra. That could be.
No. We might just leave that. Question from Chapter 8, and this is... No, I can leave that.
We're up to 30 minutes.
Yes, I'm very conscious of that, Mum. Chapter 9. Oh, this is just above 9.4. So the heading it's 9.3.6, broadcast. So we're talking about the radio station. Broadcast from 2006. And you note that as at 2016, the station remains unfunded as off-air, but efforts to seek funding are ongoing. A new proposal had been prepared. I just wondered if you had an update for 2000, seeing as that was in 2016.
I'm sorry, can you give me...
So if you find section 9.4, it should be page 529.
Yep.
This one sentence immediately
Yes.
before the heading. So as at 2016, I just wondered if you had an update. So is the station still unfunded?
Today, Raukawa is unfunded.
Right.
Yeah, and is off here. Yeah.
For the reasons that you mentioned earlier
Yes.
on.
Yes.
Thank you.
There were several major attempts over the last 14 years with major proposals and business plans, which I think were the best ones prepared ever.
I'm
by
sure they
anyone.
were.
Yeah, not by me, but by others.
I thought that's what you meant.
Professor Winiata and
I have
others.
only 2 quick questions left. Hopefully they're quick. Section 9.4.2 is the reclassification of Te Upoko or Te Ika as an iwi station and 1994 funding cut. So this should be your page 533.
Yep.
Immediately before the heading Prelude to Cut taking effect in December 1993, you note that there was the new minister, Williamson, in 1991 came in, Minister of Broadcasting, in a letter to Chairman Norrish in May 1991, insisted on major cuts. A sum of $300,000 equivalent to the salaries budget were withdrawn in early 1994. Do you remember if there was a reason given by the government for why these cuts were even needed?
We actually have the letters. We got a hold of them. And they're not pretty.
Was there any reasonable justification for the cuts?
If I could paraphrase it. Can I just say something to Raukawa people that are listening to this, why we're talking about Tupoko Radio just quickly? We're talking about it because Raukawa was a founding iwi within the station and was a joint licence holder of its frequency licence with 3 holders, Ngā Kaifakapumo, Ngāti Toa, and Te Rūnanga o Taranaki Whānui in Wellington, the 4. And Ngāti Raukawa also, in its founding trustee, had an automatic place on the board as a tangata whenua iwi, which happens to be yours truly. And it's an unpaid position, and I'm still on it. I'm the Raukawa Trustees representative on Tupoko Tika's board for the iwi. So for the folks at home, it's your radio station and you have the shareholding, and it's part of this report. The Crown became exasperated that the Pōneke Kū were researching and organising the BCNZ assets case, and then also the frequencies cases against the government. And they explicitly identified that the group in Wellington running the radio station were receiving funding to run a radio station, and it couldn't be countenanced that the funding continue. That's contained in a letter from the Minister of Broadcasting to the Chairman of New Zealand On Air.
Thank you. My final question is in relation to the health section, which is 11.7.
Yep.
And I just wanted to ask you, there's a reference to Te Whaioro Trust, a mental health provider in the northern part of the Rohi. So this is on my page 568, your page 577, hopefully, immediately above the heading 11.8 Hapu Development. My question was whether Te Whaioro trust is still operating? And yes, is it still operating? So what that leads on to is whether there'll be evidence presented about it during the course of the inquiry.
Well, we're well over now.
That's the last question. Do you know whether it's still operating?
You'll need to check with Dennis Emery and others.
They were all my questions. Thank you very much, Mr Walker. I appreciate it.
Kia ora.
Appreciate the time, Ma'am.
Yes, thank you. And you can have a look at those questions
I will,
over the break, and if
too.
you need
I
to
will.
raise anything, let us know. So we're going to take the afternoon adjournment now and give you a bit of a break. And we'll be back here in 20 minutes, which means 3:10.
Kia ora.
best performing oils under the one roof at Super Cheap Auto.
It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
Cole, have you had a chance to review those
I
questions?
have, and there's nothing arising.
And
out of
nothing
it.
further to ask.
Thank you.
All right, thank you. We'll start with you, Dr. Monty.
Ai, tēnā koe Piripi. Tutai e hea ke ngā tau, koutou ko Ngāti Raukawa i kau e nei tēnei kaupapa o tō tātou reo Māori, kei te mōhio tonu te motu katoa, ngā mihi ki a koutou. Ka hui ngā mihi ki rungi a koe, mo au kupu whakamihi tēnei ata ki te rōpu whakamani te tiriti o Waitangi. Tēnā koe, tēnā kōrero ko tai hākurei i whakatakoto kōrero i roto i tēnei pūrongo. Ka tai anō te māramatanga ka puta mai i roto i au, ko waia wai kei roto i tēnei rohe. Me te huarahi, i whai mai nā koutou, ko whata i ngā tau kua hipa. I au i te kura o Hatapāra, i taua wāra ko aku hoa no Otaki, no Raukawa, no Kauwhata, ngā te Pēti, ngā Lawtons, ngā Hakarāia, ngā Wihipehana, ngā Raureti, a Sean Ma. Engari, te whakataitai manu kōrero, ka au te kai kōrero mo te kura. Te kai kōrero i Otaki, ko Mauriora, i toa ia. Engari, ko te ngako o taku whai kōrero i taua wā, ko whakatipu Romano. He moi a i taua wā. Engari tēnei wā, ko Puawa i tia. Arera ngā mihi ki te kaupapa. Tēnei ata, ka whakaingoa tia te ingoa o taku, o tā māua ko te kai whakawā pāpa a Winmu Pāka. Tika tonu tō kōrero, nāna i hāpai te kaupapa o pare wahoha. Engari, taku tino mihi ki a koutou, nā koutou i puare te tatau ki a hau atu aia ki roto i tēnei rohe, whai muri aia ko Ngāti Parau. Ko tōku whānau te tahi. I noho mātau i roto i tēnei rohe mo te wāro, e nei kua moi ngā tamariki a Ngāti Parau ki a Raukawa, kei konei tonu ngā mokopuna. Nā reira, tāua, ngā mihi. E kore e mutu ngā mihi ki a koutou, nā te me, o koutou, a koutou tohe manga, tohe ro ki a mātau, a koutou tuna, whangai mai nei i tōku whāna. Nā reire, kore ngā mutu, ngā mihi ki a koe, ki a koutou, ko Ngāti Raukawa, Ngāti Kauwhata, me ngā hapu, ngā iwi o te reureu. Tēnā koutou katoa.
Kia ora anō koe.
A lot of my questions I realise now are for Te Hākure. And based on listening to you, I don't even think I'll attempt to run them past you. But I do have a couple for you. First on, te pātai tuatai. Hea te tikanga o te kupu, o ngā kupu nei, he iti nā mōkai. Kāre koe I whakamārama mai ki roti tēnei pukapuka?
Bueno, me waihua hau te whakamālama mō ngā tino pūkinga o te iwi mōhiu ki ngā hitori mā rātou e whakautu. I roti te roa ngā tō te wā, te hohunutanga.
Ka pai. Tuarua, te kreiti ana. E rā te tai kōrero kei roto o Ngāti Prau, nā te hāhi I tango atu te kiko tangata I aku niho. And I read through all of the Ngāti Raukawa understandings of Christianity, and I'm very interested to read Ross's account of the manuscript for Tamihana te Rauparaha ne. Where does that sit? That understanding that we were eating each other and the power of Christianity to stop that. Where does that sit in your whole understanding of Christianity?
After my experiences in radio, I ended up wanting to eat somebody. Ahoi ana. He pērā anō te Māori I ona rā, I ngā rā o mua. Te koroa te kapunga Jews ki te rohu whakamana, I te tauwaru te kaumā 5. E hala mai te tiritu waitangi kia hau ki te Māori, I te wā e piri tonana te kiko tangata ki aku nio. Wera tana kōrero. Kāri whakamā mo te rāhua. Wera te ahu o ngā huatanga. I koroa hau mo te haerenga Tamihana ki kai apuhia, ki te waipaunau. I enei rā, o tino weti tātou ki te heo ngā mahi o tātou mātua tūpuru. Ngā pake ke ngā kui e kāri tino āwangawa, I rongo koutou I ngā whakamārama iwi kātea, mo te ahu o te ao Māori o mua. Ana ka tae mai te ao hou ki te iwi Māori. Taku mōheo. Aha koe I makere atu ngā huatanga o te ao tawhito. I roti ngā tuhinga Tamihana ka kite koe. I reira tonu ngā whakaro. He mahi tērā nā tō tātou iwi. Te whakakaitoa. E tikanga tērā. E whakakaitoa I tō hariri. Hoi anō. O kukui anō e te. E te mōhio au. I roti I e rā huatanga. Engari ka tae mai te whakapono hau nei. Me tana ture matua ki kau e patua te tangata. Ki iri tia koe I roti te wairua o te kraiti e rā kore. He tere tonu tā rātou whakawhatatu I e rā huatanga. Aha koe te uaua. O te te himea uaua ki ngā pake ki o Ngāti Raukawa, I taku mōhio. O te haina te tiriti o Waitangi. Ko te whakakorenga atu o tēnei mea te pupuru tau rekareka. O tēnei mea te e ki ana he rōpā e tau rekareka. He mōkai. He maha ngā tau rekareka. O te imu atu te kraititanga. Ana koe rau ki te tehi tikanga I whakatahangia I te wā o te whakapono. Engari roti I te ngāka o Tamihana, ka iriria, ka haere ki ngā kura, ka haere hei tangata, ka I pānu I te wharekarakia, ko tana hia hei minita ia. Ka huri ki ngā mea Māori, ka hoki mai anō e rā ahuatanga o Tamihana. Ka kite koe roti ana tuhinga. Te wairua whakataetae, ana ko te āhua o te whakapono o te Māori ki e rā āhuatanga o ngā tau ki muri. He āhuatanga I mana I roto I te mano tau. A tae mai ki e nei rā hau nei, ana ka wakarere ki tāhaki.
Te hurihanga Tamihana ki te whakapono, I hau atu te wairua tapu ki roti I aia?
He tino tamaiti pērā. Ngā tuhinga Tamihana, koe kitea ngā tuhinga ngā reta, ana, nā Rossi kite. Ki ngā mihingani kia Shortland mā I te Waipaunau. He tino pērā tana wairua. Born again ton. Ana ko te uaua, Mā tātou anō e whakaaro. Tērā whakatipuranga. O te rangi haiat i te ora tonu. O te raupraha i te ora tonu. Ko ngā tamuriki tonu o rangatira kei te ki e he ana tō mahi papa. Ko te hea pēr ki te harama i te patu ngā Pākehā i pōneke nei. I muri te patunga i te wairau. Ka tū a mātene te whiwhi mā ki te ki. Tēnei te au hau, ka māhuta mai nei, ka waiho atu tēnei mea te patu tangata. Nā, ko ngā tamuriki e nei e kōranti o rātou mātua o tērā whakatipuranga. Rua te kau noho ngā tau o tāmihana. Whānau mai te tau rua te kau. Whā te kau e rua te kau ana tau. Tā mātene te whiwhi, tori te kau ana tau. Ahakoa he te maiti, karanga te maiti e kia tāmihana, he pake ke atu a tāmihana. I roti ngā whakapapa. Tori te kau tāmihana, a mātene rua te kau a tāmihana. E ne, wako whakaaro e nei, mo taku matua kēke mo tāmihana, me taku te tiro ki aia. Engari tērā uuutanga tērā. Ko te ao Māori katoa tērā me te rangatiratanga. Te kōrara a te tōpu whakamana ki a hemi henare. I te tau waru te kau Māori. He aha ki a koe tēnei mea te mana rangatira. Ko te whakautu a tā hemi. Ko te mana rangatira, ko te mana whakaola i te tangata, ko te mana whakamata i te tangata. Wera hoki ngā kai whakawao. Ngā kai whakawao e rā wā.
Te koro aku tibuna, mo te atua i taua wāra, ki te kore koe e whakātu mai ki au, te mana o tō atua, ka reo e whai atu i aia. I want to take you to a piece in your 345 on my page, which would be 444 on yours, where you are giving an account dictated by Tāmihana to Edward Shortland.
Hea te
No,
nama
hang on, no, I've given you the wrong one. Well, forget the page. I know the account. It's of Hadfield having sat down and he bit a kumara.
Yes.
And there was a tohunga who took offence
Yep.
to that and
Yep.
tried to strike him.
Yes.
And the short of it was he was protected by a woman and a curse was put on him and he said it wouldn't affect him. He disappeared for some days and in that period the tohunga died.
He died that same night.
Same night.
Yeah.
That's what I'm talking about. In our area, demonstrations of the power of your God led people to convert or to turn to Christianity. I was interested in our discussion about born again, as you put it. Te hau atu o te wairua tapu ki roti a koe. But not everybody not everybody is affected in the same way. It does take the whole of the East Coast from Whanau Apanui to Wairarapa converted because they saw in a battle the strength of this new God. And I wonder, did that influence people over here? That actual, what happened there with Hadfield and the Tohunga?
It's said, in Hadfield's life story, he regards that as highly significant, and that's described in that chapter of my report, that was a highly significant thing, and he just, I think, shrugs and says it was fortune. You can't say what was going. He was a very, I think, sort of clear-minded kind of a person, but I had my own conclusions on this, and I do think that the missionaries were courageous, and it wasn't just those kinds of contests. In general terms, I mean, if you read the diaries of Mary Ann Williams and others, I mean, they're pretty amazing women folk too. They were on their own. And you know, the war leaders and the warriors and those in Toi said, you know, the biggest problem was breaching tapu inadvertently, often, and the children were doing it all the time, and a lot of the missionaries were saying, we won't accept that, and we don't accept muru. It's thieving, which is the muru is the justice system, and yet the people were fairly unflappable, and I think over time that impressed them. The courage is admired by Māori, and recognise it.
They're a completely courageous group of people, and they would say, well, what if you die? And they would say, well, I completely believe that the Lord my God is going to take me to heaven. and those sorts of exchanges. And my questioning over the years that I've spent on Marae with a lot of ministers, because I've asked a lot of ministers this, why did Māori convert? Which I think is your question, Dr. Monsi, why did they convert? And the question I've got most commonly from them was, Māori bought the absolute unshakable belief in a second life after this rather rocky one. They believed it. And it's my own belief, and I use this phrase, that the Māori had a genuine and profound conversion. I think it was a deep conversion. I think a lot of societies that have apparently converted, I think often the men folk in particular, if they've got a very, very strong military tradition, don't convert. They keep a village-based militia in operation, and they continue right into the present. They blood the young men young. So I think you'll know what I'm talking about.
Well, that's you're right. That's really what I wanted to know. Why do Māori convert? But I'm going somewhere with this, just to finish, because I know I've got a captive audience of Ngāti Raukawa out there listening at the moment, and you have told us that 50% of the students at Raukawa are now pluralism, I think is the term you use.
Can I just say that's a figure I plucked out of the year? There was a lot, and in my estimation, it might have got to that point at certain hui, in terms of the sentiments expressed. So that's not scientific, and that was in 1994, so it's now out of date. And I'm still teaching at the Wānanga. I don't, not so much this year because this was coming up, but last year I was there a lot, and the Wānanga, I think, would want to talk about that, and I think it's quite personal information too for the students, but. I don't mind sharing with you the older figure from 30 years ago when this was really a big question. The students, we had to debate whether we would continue with Christian karakia. That's quite a big thing on Marae, eh?
Yep.
You get a mixed group nowadays. But I believe myself the secret is to be vigorously pluralist.
Yeah, that's interesting. Yeah, I don't, right across the country it's the same. I would say the numbers are up there everywhere. I suppose really what I was going to is in terms of looking back at that period, though, when people like Tāmiahana so-called converted, some of us look back and think we were duped by the missionaries. But I've always thought to do that is to demean your own ancestors and their intelligence. Pēo whakaaro mo tēnā.
The problem was the evidence is that there was a bit of a huge, in the grand scheme of things, there was a huge, large effort to depower Māori society, and that's the evidence, because the evidence because.
Do you mean by the missionaries?
Well, was Te Ao Pākehā Christian? If Te Ao Pākehā was a Christian world, then Māori would have operated and moved forward on the basis of friendship and mutual respect, and Māori would have their land. And there would be major business proprietors in the way I described earlier, and many other things, if they'd had that equality. So the evidence was, and that's where all the haka come from. Ko te paipera, a te tiro ki runga kei raro ko te rahura. E rā kōrero, and that has entered common Māori discourse as a received truth. And that has come across to the general legacy of general mistrust.
I've set you up for this, Judge.
Thank you. We were discussing your report the other day, and I noted I have questions about the influence of Christianity as well. So I may as well go follow on from Dr. Monti, if you don't mind, and then send the questioning down to the others who are on the panel. Page 337 of my volume, which is the same as Ms. Cole's, and I understand there's a 9-page difference, and I can't remember whether it's forward or backwards.
I think I've got a different copy now, which might be right. So if you give me your page number.
Okay, so it's page 337.
337. Yep.
So you deal with the arrival of the missionaries in the district and the fact that they were different to whalers and early settlers who entered on Māori terms, who entered the society on Māori terms.
Yes.
And lived in accordance with their legal system.
Yep.
and you recount conflicts between tohunga and missionaries, and the example that Dr. Monty gave you is the one I'm thinking of immediately. Do you think, it was a clash between Hadfield and Mātinga Te
Mātia.
Tia.
Yeah.
So do you think the Crown should have done more to control the missionaries during the period post-1840 after the treaty in terms of how they interacted with the iwi in this district? Or do you think, because Hadfield was one for the books, he was one who has moved into the hearts of Ngāti Raukawa because of what he did during the land sales, that you can't really answer that question?
I don't know if the Crown could. Yeah, Dr. Phillipson might know the extent of state control over Church of England missionaries is an area. Yeah, I began writing this without deep knowledge of these matters, so
yes,
it's hard for me to give an answer.
Before you answer, everybody else was here under the authority of the Crown, so I presume the missionaries were too, even though their greater authority was God and the Church. But after 1840, everyone's here under the authority of the Crown, you'd agree?
Yes, I would agree with that, yes.
Yes, so everybody else is under the control of the Crown, those who are settlers.
Yes.
What makes missionaries so much different? Don't you think that the Crown had some responsibility to exercise some control over their behaviour in the districts?
In the Māori worldview of it, they should have been prevented from suppressing tikanga.
Yes, well, that's where I'm going with this. Yeah. So then, do you agree that the missionaries perpetuated a Christian-based value system that, according to your evidence, seems to belittle, deplore and reject Māori spiritual beliefs, and that they directly challenged this aspect of the Māori way of life? And if you need references, I can provide them from your report, but they're littered throughout that section.
Yes, I would agree with your statement. But we have to imagine and go back in time to their world, to those missionaries, and as I understand it, and it's clear from their writing, that they believed that the first commandment, "Thou shalt not have strange gods before me," and so on, and I end it with the old King James end quote, "My God is a jealous God, you must break down all their idols," and so on and so forth. That was the school in which they were raised, and that was Christianity at the time. I think it was probably Catholicism at the time. You weren't allowed to do the old karakia to different gods. And there's other tracks I've got interested in this too. Knowledge of, I mention it, I think in my report, the knowledge of ritual and the knowledge of karakia. The big old waiata oriori in our area that you will so well know on the coast, and the fact that you had people like Paratene Ngata and his son Apirana who actively conserved and preserved them. My sense in our rohe is that under the influence of Hadfield and the it's not fair to name Hadfield, the influence of the missionary instruction at the time, they were required to place those in a cupboard and lock them deeply into a steel vault. You know, and there are many, many of the treasures that people did not want to engage with. For example, one of them, I think he's the founder of the Tainui School of Religion, Ngā Toruirangi, and all of the Hawaii cycle in the big section of the manuscripts that Te Rangi Haata left. And Arini, Dr. Lotus says, in fact, Martin Edewhifi knew them and was able to write them himself in his manuscript books. There's a book-length treatise on Ngā Toruirangi and the whole of the cycle, the Hawaii cycle. Very, very few of our kuia and grower would have known about that, but it's at the central core of the stories, and quite teachable stories. You know, the wonderful development of conflict in Hawaii, the big battles, how Ngā Toruirangi came here and then he was cursed by his brother-in-law. You always got to have a brother-in-law entering the picture offering a good curse. And then the sisters fly here with the aid of Itupaua, Rongomai, the gods, the iwi gods. They can fly. Well, you can imagine Hadfield's face. And there's beautiful big old songs with it. And
Right.
I don't think that the kaumata and kui of those generations felt able to continue with them at all. That's my study of the evidence there.
Right. Well, thank you, because I've looked also at what might be the benefits to Māori and based on the research you've done, and there are a number. So according to what you've said in this section, which is pages 345 to approximately 356, they provided some form of alternative dispute resolution to undertaking warfare of the type that Te Rauparaha and Te Rangiai Haere understood. They provided some opportunity to convert to a more powerful God. They provided a sense of security, an attempt to keep neighbours at bay. I understand Shelby's work indicates that they acted as a form of a buffer between iwi in this district. Literacy and conversion to agriculture and horticultural pursuits.
Yep.
Would you agree? So if that's what the evidence says about the benefits, what do you say were the negative advantages, negative detriments to having them? For example, you mentioned one before, which is in Māori, you were talking about the fact that the children weren't listening to the parents.
Yeah.
And how big a thing that was for the men of mana of Te Rauparaha and Te Rangitai.
Yeah.
And the denigration of tikanga, which is at page 339 to 347.
Yep.
The attacks on tohunga, karakia and metaphysics at 347.
Yep.
The attacks on the cultural arts, which is why Te Rangiatea had no form of cultural adornment, according to your page 348. You can correct me if I'm wrong.
Yeah, but some in the we have other versions of the reason for the no carvings there, which they may talk about when you come to Otaki.
Right.
There are other stories as well.
But that would be consistent with what happened in the rest of the country, wouldn't it? People
Yes.
didn't put up Māori art forms in churches because of the denigration of those forms by the missionaries.
And in fact, Samuel Williams is one of the Williamses here explicitly,
Right. And
desperately hoping that it
pacification,
won't
would
happen.
you say that was a detriment or a positive?
No, I would say it is a detriment that the full-scale conversion project tried to impose a worldview which classified Māori culture as not as advanced and not as desirable, and tried to create Māori as Europeans.
Yes, and then of course the whole spying thing which you referred to at
Yes.
page 356.
Yep.
So that raised for me the issues that we're going to hear more about in Nomua Atienga Hokanga, because one of the things the authors of that paper raise is the fact that the missionaries actually helped the Crown keep the Māori partner of the treaty in subjugation, because the only literacy they ever helped develop within Māoridom was literacy in and around the Bible.
Yeah.
And not enough was done to help educate Māori about the intricacies of, say, land tenure in English custom, and English customs relating to other ways of life, like marriage and all of those various things. So I wondered if you had a view on that.
Well, David Williams and the others talk about the politics and the debate and the journalism in the 1840s, saying that the literacy that was developing was actually quite broad and quite highly developed, and that Māori were reading all the newspapers in Wellington from 1843, and that Ngāti Toa were engaging journalists and actually writing their own letters in English in order to advance their side of the story. That's in this book. Wi Parata, David Williams' book. And Raukawa were very vigorous participants in the Māori newspapers. But that, the big flower of them came later, and it's true that the ones in the 1840s were mostly government, Te Karereo Pōneke, and those other very early newspapers. I think Māori were involved in reading them, but I think
what you've done is you've highlighted
Yeah.
what happened in the 1840s,
Yes.
and you could probably say through most of the 1850s.
Yes.
But are you talking about the flowering of literacy and more understanding of what was happening during the 1860s?
The 1860s. Within the 1860s, everything went terribly badly wrong. There was 1860 war, and then the Land Court coming in 61, and then the Second Land Court very early in the 60s, and things became, I'm sure things became chaotic there and then the land sales emerging in the late 1860s. So, in a sense, the proposition you put to me about the curriculum and the journalism and the material put in front of people being mostly Bible-based, I'm sure that that was very true. But I'm not sure that Māori and Rangatira said, now we're Christians, we can't read anything else. I'm not sure that that's true.
Yeah.
But I don't want to cut across what's going to come to you tomorrow.
I would agree with you. I just wanted to get your view on it because you've studied it, you've got this whole huge section in your report on it, and we're going to hear from the other people tomorrow. But you're an expert in this field. I wanted to get your view, so thank you. All right, Ms. Simpson.
Tēnā koe, Whiripi.
Kia ora anō koe.
Ko ana te ngākau te whakarongo ki tō reo, kōrero mai nei, whakamārama mai nei ngā watanga mō te iwi. Tautoko ana ngā mihi kia rātou, kua mene ki te pō. Rātou I kawe mai nei ngā kaupapa I mua. E tikana kia moe rātou I tā rātou moe, waiho mā tātou I te ao nei e kawe nei. Mā ngā uri whakaheke, kei a rātou te ao, nā reira, e mihi ana ki a koe. Just following on from the kōrero about Christianity, there's a reference in your report at page 343 that there was an expectation that the process of baptism into Christianity means also baptism into a different culture.
Yes.
And then it carries on this debate about the cession of cultural identity upon entry to the new faith appears in the oral tradition of the iwi. So the expectation that when you're baptised into the faith, you're baptised into the culture. Is that an expectation of the church? Is this saying that's an expectation of the church or an expectation of the iwi, or where does that come from, I suppose?
There's a very good thesis by Rangi Nicholson on this, on the nature of the accompaniment of English culture. He just says, arrival into the baptism of the Anglican Church was very much a baptism into English culture. It's a very good piece of work. He was my boss for years running the immersion. We used to see these things played out in action on the marae. I mentioned the case of Ruka Broughton earlier. In our rohe, one that's not in my report is Uncle Pat Ray, who I've mentioned earlier today, on the conundrum of where you get to in terms of your religious identity, and can you be a Māori, believing Māori, and can you also be a Christian? And he was quite clear. He used to say, I believe in both. O taku Māori, o taku ngākau, me taku āhua, me taku wairua Māori. And he was an expert on the whakapapa and traditions. And then he said, I believe in the other four, taku halawaihan, my salvation. That's what he said. It doesn't directly, exactly answer the particular point of your question, does it? Does it? It doesn't quite.
No, that's okay. It just struck me that I wondered whether it was a belief, a commonly held belief, that once you are baptised, you've gone over to the other side, I suppose, and you've changed your identity.
Yeah, and also I think also it was pretty strong. I think some branches of Christianity that arrived, Dr. Phillipson might have studied this, were pretty staunch and conservative. In some parts of the country, it might have been the personality of the missionaries who arrived, but some of them seem pretty straight down the pipe. You can't deviate too much. I am the Lord thy God, and thou shalt not have strange gods before me. And it's a sin to even think about the other one.
Mm.
And it's a sin to start believing in the old, you know, hei te mō tātou ki e te heo ngā huatanga. Kau e kōrero wawe mō zēni mea te mākutu. E rā ahuatanga. He nui ngā kōrero mō āpirana, ngā koranga. Mākutu ngā uri hei kōrero. But I've heard kaumātua from Ngāti Bro say that āpirana used to say, i te ki mai he tangata, he mō hea ki ngā tua Māori, he hori ori re rā. It went, I mate I a rātou. I mate I a rātou. And I've reason to believe that that was an accurately heard statement from Sir Āpirana. We're allowed to make him a kaumātua of ours, aren't we, Dr. Monty?
As an aside,
Te tangata nāni whakaero te motu.
As an aside, can I just let you know that his son, before going off to World War II, went to see his ringatu auntie with a coin to have a bob each way that he'd get back from the war if she blessed them as well as the Anglicans.
Tainare. Oh.
Kia ora. And I was going to ask you about Rangiatea whare karakia, but on your response to Judge Fox, I wondered if you are suggesting that we leave those kinds of questions about whakairo and well, the question I had was while whakairo may not have been prominent in the whare karakia, tukutuku and ko whaiwhai are, and so how does that distinction come about?
Yes, between the other decorations and the other arts and all.
Well, the wairuatanga of ko whaiwhai, the kōrero and the wairuatanga associated with those art forms acceptable, but the whakairo not acceptable. Where's the distinction?
Yeah, in general terms, I don't want to trespass on Rangiatea. I'll leave that for the holders of the tradition and also the hapu there to talk to you about the whare karakia. But I will just mention the quote in here, which is quite explicit, where the missionaries found the figures of Māori carving grotesque. And in my estimation, because I think what they're reacting to is the psychic power that Hirini Moko Mead talks about when you encounter the work of masterworks in Māori art. It was tremendously challenging. I believe the whole Māori religion was very challenging to all clergy because it's so magnificent, actually. I think it's no accident that many of our clergy become quite expert Māori. And at tangihanga, they don't stop at doing the karakia, they actually address the spirit of the dead. I've often teased priests about that. You know you're not allowed to do that. We ngā mahi a ngā tūpuna. But they're drawn to it.
And if I can switch tracks now, just going back to Te Wao Te Rauparaha, and that we've been talking a bit about that nexus between his world and his son's world. And when he came home from Wharehere, were conditions put upon him that you know of? I know for some other rangatira that were imprisoned, their release was contingent on a number of things, behavioural, political conditions. Do you know if those types of conditions were put upon Te Rauparaha?
I think that would be a question for the Ngāti Toa historians to answer. Yeah, I'll leave that one.
Okay.
Yeah.
Then turning to the radio station, you mentioned when you were discussing the communications with Ms. Cole some letters, and I wondered whether the tribunal might be permitted to receive copies of those communications relating to the responses of the Crown, or the communications between the parties in respect of funding for Raukawa's radio station.
Yep. The particular radio station has a claim in front of the Waitangi Tribunal lodged last year on many of those issues. And in preparation for it, I and others have been doing research in the archives. And it's turned out that those particular letters have now, parts of them are, for the moment, lost. That's a really interesting loss of documentation. But you've inspired me, Ms. Simpson.
Can we leave that with you? And if you see,
we'll do our best.
If you do have something that you think is relevant, could you maybe?
I have memorised the missing paragraphs, but it would have to be oral history.
Kōrero tuku iho. Ka pai. Okay, I think that's it for me. So, tēnā rākoe.
Dr. Grant.
Kia ora.
Tēnā koe Piripi, and thank you for your contribution to this report. Most of my questions are more 20th century, so we'll move into the 20th century. And I'm wondering, well, some of them are partly 19th, but in chapters 3 and 4, who actually officially appointed the board members for the trusts board that you talk about, and the trustees for the Raukawa Marae? What was the process for appointing members, and who made the decisions? For the board, for example, did the Raukawa trustees nominate some of their own membership, and to whom did they nominate, and who appointed that kind of technical? Who I'm trying to work out.
This is for the Otaki and Porirua Trust Board?
Yes, and the Marae trustees.
Again, I'm going to ask, when we get back to Otaki, to ask current office holders if they can recall who made those exact appointments. Because of the number of institutions, I didn't get to that level of detail that I can record on the appointing process. My recollection is that the bishops and certainly the Trust Board was very much a church institution. At the time, it had its offices in Wellington,
right.
And it may well have been the church, but if you could park the question until we find an office holder.
Thank you.
Yeah.
And I have some questions regarding chapter 5.
Yep.
I might ask, there were two that occurred to me listening to your summary, and I think you can answer those. The first relates to the end of paragraph 5. I'm just confused. It says, the council asked for restrictions on toemanga, toeroa, and birding for the supply of food parcels. Is that asking for restrictions, Crown restrictions, to be lifted so that they can be supplied for food parcels, or is that asking for restrictions on others using them so that there's... I'm not clear what that sentence is saying.
That's Teihā Kure Jury's chapter, and he'll be here tomorrow.
So you don't know?
And I don't know, and it did confuse me slightly now that I've read it and you've asked me this question. I actually read that the other way. But...
So we'll have to ask him.
We'll have to ask the person who actually knows. Yeah.
Okay, thank you. Yeah. And that's probably the same for the other one.
Yeah.
So I'll leave that. Going ahead to, I've written in page numbers for you now, doing the calculations in my head, but I don't need that now. So page 487, and this is the paragraph under the heading 7.15.
Yes.
There's a mention there of a form of declaration of sovereignty, and I'm wondering what that refers to. trying to find it.
Yes, about line 10 there. I can see that.
Yes.
The trustees adopted an organised program of withdrawal from and non-cooperation with all unjustly framed government activity.
Which involved a form of declaration of sovereignty by the Māori partner. Can you explain what that was?
Yeah, well, I think there was a kind of a rule, and it was a Māori rule based on mana motuhake. And I think the rule was probably something like what the treaty required. And I think this tribunal moved towards that eventually, a treaty-compliant set of negotiations, or, I hear that talked about now, and they framed one pretty early. And I know, I had direct experience of certain of them. You weren't encouraged to go into a body, or some of the, the organisations in Wellington would have a single Māori staff member. And I recall several of us being told not to go there by kaumātua.
So I was
not to work under those circumstances, especially if it was a voting body and you had one vote. That was rejected. So they were saying the time for that is over. Tangata whenua can't be outvoted anymore. And then the word withdrawal, whatarangi winiata, was the proponent of this and other phrases. Withdrawal was the idea of moving out of those bodies where those practices were still done. And for Māori to regather in more fruitful places where there could be a sense of Māori doing things together. And also people weren't fighting on their own in these large bodies. And it may have been experiences. I think Whatarangi Winiata was on, for example, the Broadcasting Corporation board as a single Māori, and that was their practice to have one. He was succeeded by Tipene Regan and then Katarina Mataira, Howard Morrison. But the experience was you could never get much through,
right?
Because you're only 1 on 10. And so there was a sense of withdrawal. And then on other occasions it would manifest itself in other ways. The 150-year project to write Ngā Tāngata Taumatarau, the New Zealand Dictionary of Biography, led by Bill Oliver and Dr. Orange, ran into difficulty in Arohi. They came in and the approaches were excellent. They used senior kaumātua. Wiremu was one, Pāka, and it was a good kaupapa. But they said, why would we celebrate a treaty that hasn't been honoured in 1990? This was started about 1987. And some of us have been asked to write biographies by the project. I know, I was asked to write the biography on Tamihana Te Raupara. And the Raukawa trustees asked us to put down our pens and not write.
Okay, thank you. You may not be able to answer this one, but you did say in your chapter on the Māori Women's Welfare League that the league, and I think you were referring to the branches, the local branches, as well as the national body, addressed itself in a major way to political issues, but you didn't say in your chapter what issues those were and with what success. So can you help further with that? What are the political issues they addressed themselves to in a major way?
The Māori language was certainly one of the major ones.
Yeah.
They and schooling and education issues from the league. They established relationships with ministers of Māori affairs in particular, and a very close relationship was encouraged there, and they expected their voice to be listened to. They invited those people to their annual conferences, and political issues were discussed. Mm-hmm. When Mina Kasazi was the chair, she instituted a practice where the women would invite a guest speaker on a really meaty topic to the conference. As she put it, he tangata he mohu ki atu, he nui ki atu, no atu ngā mana o tanga o taua kaupa, ia mātou ngā wahin, tā mātou he whakalonga ki taua tangata. And he pātai, and so they would seed new ideas and along those lines, about all sorts of things. But then again, some were social. They were big on education. They were very big on interventions in youth welfare and on matters of truancy and so on. But you know, they were just. I think they were. What would you call it? The Raukawa ones, I'm very proud to read the minute books because of the things in the stand they took. The Raukawa Wk went to the national conference and there was a discussion about using the funds for certain members to go and stay in a hotel. And there was a ban by the Raukawa Wk. Me hoki mai anō ki te kaupapa.
Thank you. That's given me some starting ideas. And I've got two more questions. One's more general, and I'll start with that one. In terms of Whitireia and the Whitireia College, up until now, I've always heard that spoken of as a Ngāti Toa kaupapa. And when we had our hearings at Whakarongotai, it was described there as the Ngāti Awa kaupapa.
Yep.
And here I'm hearing of it as a Ngāti Raukawa kaupapa. And I'm wondering, can you tell me what the connection of Ngāti Raukawa is to that Porirua
Well, the two
deal
chief,
with the church and the Crown and the establishment of the trust?
the two rangatira that signed the 1847 letter and the 1848 letters to the governor, because it had to be made to the governor, were both Ngāti Wia.
And they were?
Tāmihana te Raupraha and Martin de Vivi.
Right, okay. So is this a case of everybody from Porirua to Rangitike being able to be both those great leaders of that stature? Because it gets quite difficult to classify, if you like, in a way that we don't offend anybody in what we say.
It's Ngāti Raukawa claims Raupraha. Are you aware of that already? I know.
Yes, through the Ngāti Huia. Ngāti,
he was present.
He
was the president of the death of my ancestor Hapiki Tuarangi. So my question might be, which iwi did Hapiki Tuarangi belong to?
And I hope you're not posing that to me.
He's the grandson of Wia.
Right.
Hape. And he was the one, Raupraha, received his mere amukura, which is in this museum. At the moment it's out with Ngāti Toa, as it should be, hei tiro tiro manga mokopun. And his taiaha, Kimihia.
Yes, Ngāti Kimihia was his...
That's his grandfather.
Yeah.
That's the name of his taiaha. And so, in all of the campaigns and in all of the relationships, they were close. And they would have been consulting with their kuia and Kaumatua about what was the right thing to do and gaining the gauge. So Raukawa were interested to all of those times and in all of those activities.
Yes, and I guess part of why I'm trying to get my head around it is the kōrero we heard from Iwi Nicholson and the issue that's going to be talked about a lot tomorrow, the difference between a gift and an allocation.
Yeah.
And the way you're thinking about it, if I'm understanding it rightly, helps me with that. So thank you for that. And then my final question is a very specific one, and if you can't answer it, I'm hoping that someone can, and that's the... you talk about the the foundation of the Runanga and the Iwi Runanga Act, and I'm wanting to know first of all whether Ngāti Raukawa representatives attended the 1984 Hui Taumata and supported the idea of devolution. What was the view of Ngāti Raukawa, or views of Ngāti Raukawa on the bill that was introduced? Excuse me, because you said some iwi and critics were not happy with the bill when it was introduced, and I'm wondering if Ngāti Raukawa were among them. And thirdly, whether Ngāti Raukawa opposed the repeal of the Runanga Iwi Act.
Right. All four questions, I can't give you an accurate answer, but I think I can undertake to go away and find the answers to all four of those questions.
That would be wonderful.
Yes.
Great. Thank you very much, and thank you again for your very helpful report.
Kia ora anō koe, Dr. Phillipson.
Tēnā koe Piripi, ko tai ki te musunga o tēnei wā, me mihi atu au ki a koe. So, are there any follow-up questions?
No, Mum.
No, any follow-up questions?
Ma'am, you'd indicated an interest in hearing from Piripi about the structure and intent and methodology behind He Tina Motai. He's prepared a response if you would ask that. He oi anō kei a koe te tikanga.
You said it would be helpful.
It's about 4 paragraphs, Judge.
I think it was Dr. Monty who asked it.
Oh, kia ora. I think you indicated it in one of your instructions that came out, Judge, about 3 or 4 weeks ago, that you might ask myself or Dr. Loader what
that's
sort
right.
of what
Yes,
sort of
sorry.
evidence this was, and to what extent it should be tested.
Yes.
And I've had to think about it and taken advice. And can I submit this because of the timeframes with the idea that our kaumātua, Tai Hakure and others might come in with corrections to it, although it has been advised on. I present a statement in answer to the question and instructions from Tribunal Chair on the nature of the material presented in He Iti Ngā Motai. Tātai kōrero and whakapapa within Te Ao Māori were transmitted orally under controlled learning conditions to chosen persons and imbued with tapu. Kōrero tuku iho, whakapapa and mātauranga knowledge are revered and highly treasured. In my review of the material and the other 3 sections of He Iti Ngā Motai, I and others I've consulted with affirm the material is Māori material of that nature to a significant extent, coming from within the whānau and the hapu in the first instance, and supplemented by other trusted written sources esteemed necessary. I should say both in manuscript, extensive manuscript, and printed sources. The 2 sections by Dr. Ardini Loader on iwi origins and Ani Mikaere with Whatarangi Winiata on rangatiratanga, that's part 4, have been compiled by kaumātua and highly trained academic experts with impeccable iwi credentials. There is also a section on institutions of the iwi, the one we've just run through. I was asked to write, and to which Tai Hakure contributed his chapter. The reasons for beginning such a project are summarised on page 3 of volume 1 of the report. There, the compilers outline the preparation of a scoping report in 2013 on production of iwi and hapu narratives for the purposes of assisting the Waitangi Tribunal claims hearings. Members of Ngā Māngai met twice to review and approve the final proposal. At its central core was the preparation of individual reports on hapu, one for each hapu, prepared by each hapu. Professor Winiata identified that a crucial element of the project was to develop the capacity of the iwi in the areas of research, writing and associated scholarly pursuits. Accordingly, the team shaped its plans to maximise the engagement of iwi members at every level. The writers declared that among the obvious benefits of the model were the extension and expression of pukengatanga, kotahitanga and rangatiratanga amongst the coalition of hapu affiliated with Ngāti Kauwhata, Ngāti Raukawa and Te Reureu. Future negotiations with the Crown would benefit from being imbued with a commitment to unity of purpose across all whānau, hapu and iwi, including diversity of interests. In his conclusion to the hapu reports, which I hope he will present to the Tribunal, Dr. Wali Penetito describes the flow and shape of most of the reports which emerged. They began with when and how the hapu arrived in the Snohe, something about the leadership and nature of those who took part in the hekinga, stories about the land, forests and waterways, the plentiful supply of food sources, and the life of the hapu and their environmental niche. There follow in the hapu reports stories of resistance, resilience and survival, stories of economic independence, of loss of land, retention of hapu mana, and maintenance of marae and the loss of te reo Māori. The question, to what extent should Te Iti Ngā Motai be tested by the legal process? I would answer, it is not a candidate for any such test from an outside culture. It will stand forever as the kōrero of the hapu and the iwi as a whole. Not a day in its life nor a year, but an accurate word and visual picture of several centuries of the life of Ngāti Raukawa, of Ngāti Kauphat and Te Reo Reo. It speaks the truth in its own heart. The report has been written and conceived through Māori eyes and Māori hearts, at the direction of wise and seasoned kaumātua. It covers the last 2 centuries of loss of rangatiratanga, land, language and betrayal by the Crown. It should be treated as an eyewitness account, as true as an account can be when judged by experts in the culture. Kia ora.
Kia ora. Well, thank you. I'm now recalling that I did that before the last hearing. So it's good to have a clear explanation of its status. We had a exchange with council about it, I think, so now we've got something in writing about that too.
Kia ora.
So, kia ora ki a koe.
Kia ora.
Can we just ensure that we get a copy of that?
Yes, I don't think that prevents you asking questions of clarification on the content of it.
Oh,
as
no, I have no
understand.
questions. No, I'd just like a copy of it, please.
No, I mean of the document itself.
Oh, yes, no, I understand what you're saying. Yeah.
Well, we've now arrived at the end of the day, I think, so we've finished hearing from Mr. Walker, have we?
Ai, kia ora.
Kia ora.
Kia ora no koutou. E mihi ana ki koutou. Katoa, tō koutou ka. Tag ki rano hoki, tēnā rā koe pā, tāta amachi. Te hungi tīmata tēnei no. Rōpine ana, e whi hoki a Rōpine, Anderson. Nā. E te heo koutou ino hui tēnei o ngā rura. E te me. Me te tangi anō. Kia ora, tātou, katoa.
All right. Thank you, Mr. Walker. All right, we're at the end of the day, so I wonder if we might ask Tekini if you would close us, unless there's anything I need to know in terms of the administration for tomorrow.
Regretfully, Mum, I need to seek leave to withdraw for tomorrow's proceedings.
Yes, we were noticing the number of lawyers who are leaving now that tangata whenua evidence has started. Thank you.
Mum, I just have one matter.
Yes?
I am very sad to say that Mr. Morrison has taken a job elsewhere, and today is his last day with the tribunal, with the inquiry, so unfortunately he will be retiring this afternoon also. And I just wanted to say that I wanted to thank him personally for the effort that he's put in over the last 2 hearing weeks that we've had, the tremendous amount of work that he's done to assist us.
Well, Mr. Morrison, we're sad we're not going to see you to the end of this inquiry, but your contribution so far has been enormously helpful, even, can I say, the cross-examination you conducted today, so thank you. All right, we're at the end now, are we? Tekini.
I tēnei wā, ki taku nei tuakana, hoki, Perepi, ka nui ngā mihi ki o koutou o te tai pūnara. Whakarongo ki te manu korori korora, kororotia mai no tua whakarere. Whakarongo ki te manu e kore ki ana i te ata, i te ata, i te awa te. Nō reira, tēnei te mihi ki a koe matunu i te rangi. Nāna nei ngā mea katoa. I te wākau tai tātou, ki tēnei wāhanga o te rāne, kia manaki i a mātou, i roti tō aroha, kia whakatau tātou, i roti te wairua tapu, o ngā mātua tūpuna. Nō reira e te matua, nau te kaha me te rangi māretanga i te wā, ka hoki ki ngā wā kāinga, tēnei te inoi, i roti te ingo tōtama me te wairua tapu. Āmene.